239.
453.
May be pardoned to mention. Once UNTC 2024, it was listed, it was in the list for last 2 weeks. It has been struck off for some reason. Today it has not come. Relating to VRS, it has not been considered till date.
The order passed. When was the order?
5/7/2023, last year.
5/7?
2023, my lord. Till date, it has not been considered, for which, my lord, the petitioner's medical practitioner, she has not been able to.
All right, give it a slip and give the number to Learned AGA.
My lord,
Case number.
My lord,
my lord.
my matter is the regularization of service. The opposite party violated the order of the writ petition.
When was your contempt petition filed? When did you file your contempt petition?
My lord, 2024.
Huh?
2024.
24.
Yes.
And the first case which I am going to take up is of 2015.
Kindly.
So let me have some control over the pending matters. I'll take up all the matters, but please make a mention after 2, 3, 4 weeks.
Immediate action required for the opposite party humiliated to petitioner. You could not come to office.
Which officer has humiliated?
Pardon? Kindly.
All of you give your slips. I'll sign.
Item 19 Odisha
Withdraw.
This is specifically urgent manner. Contempt specifically urgent manner.
My lord, item 145 and 146, my lord, the orders have been complied with and for the petitioner, my lord.
145, 146.
Item number 17, order has been complied. It is 79, item number. Item number 117. 155, item number. The matter of 2020, it was specifically urgent to 6th October 2023.
Make a mention after 2 weeks. Wait for 2 weeks, then make a mention.
Item 18, 22, 18.
18, just a minute.
Item 15 and 26. 15 and 26. 14 and 26 and 26. Item number
Just a minute. Just.
item number 39 permitted to withdraw. Item number 59. Order has been complied with. 59. No stocks.
My lord, item number 47, no instruction. And item number 229, also no instruction. And item number 249.
Just a minute.
Complied.
27 to 29, no instruction. 47.
47, no instruction. And 229, no instruction.
No instruction.
And 248, complied. And my lord, 265, no instruction.
Okay.
312, my lord, 312, no instruction. 292, also no instruction.
292, no instruction.
No instruction.
292.
Item 34. Yes, sir. Item 30 also no instruction.
30. No instruction.
Item number 1.
My lord, the complaint affidavit I have filed dated 4/7/24. It is online filed, but today I have filed the hard copy. There is
Who is for the petitioner?
is for the
No, Lord.
every compliant.
Yes.
We will agree.
I have received so cause of reply, my lord. A provisional pension is a valid, final pension is not a valid.
My lord, that was a direction that arrear salary with pension. Arrear salary admittedly paid. And so far as pension is concerned, provisionally, your lordship may kindly have a glance at para 7 of the so called affidavit today.
Where?
Of Kotak DES. My lord, in this case, your lordship has directed the personal appearance of all the DEOs of Puri. But actually, the DEO of Kotak is the joint disbursement authority. He has not, wrongly, he has not included the DEO Kotak as a party. DEO Kotak has filed the affidavit because he has to comply the order. But nevertheless, all the DEOs are present before your
Let us
lordship
see.
and including the DEO Kotak.
Let us see. Let us see where is
Yes,
the
my
order.
lord. Page,
Let us see the order first.
yes.
The order was passed in 2014.
Down now, order place corner. Yes, my lord. Holding that the petitioner is entitled to all his emoluments till he was superannuated. His pension also be calculated properly and its annual salary as well as pension be released within a period of 1 month. So pension and arrear salary. So far as arrear salary is concerned, everything is clear. That my learned friend has agreed. Only for the purpose of pension, your lordship has asked the personal appearance of all the DOs. So far as pension is concerned, I will draw your lordship attention to my so cause, paragraph 7 at page 4. The lordship may kindly have a glance.
Petition है.
Lordship may see para 7 of my today's so.
Just a minute.
Yes, ma'am. Sorry.
Yes.
Yes, para 7 may kindly receive.
Yes.
That on 19/10/2022, the petitioner submitted application with all required documents for grant of provisional pension, which was sanctioned in his favor by issue number so and so. For release of-
Forget this. The order was passed in 2014.
Yes, my lord.
So what did you do thereafter?
Sir, my lord, we have already paid the family pension of rupees 32 lakhs. Only 1,000 differential amount. He has applied late and we have sanctioned it.
So this is regarding differential pension.
Yes, only different 1,000 per month only.
Oh, whether you have granted him final pension.
Yes, 32 lakhs, 31,000 we have paid him recently. So far as the barrier pension dues are concerned, he has received it, 32 lakhs. Only 1,000 differential amount after the approval of final pension, it will be paid and it will be done soon. I have.
Saying approval of final pension, it means final pension has not been approved.
That is, he has applied recently. That is-
Why? Why should he apply?
because he has to submit certain documents.
This order was passed in 2014. What did you do?
My lord, we have already paid the entire dues, only 1,000 differential amount.
This is not the question. You have not sanctioned final pension. You did
Final
not sanction.
pension retrospectively, we will be getting from 2009.
And I understand that if the authority slip is issued today, he will be getting the arrears accordingly.
Yes, madam.
But why this 2022?
But your lordship may see that recently he has applied for, we will apply for maximum within 2 weeks. It will be, his final pension will be sanctioned with all area final pension, maximum 2 weeks. Paragraph 9 we have stated. In
What
paragraph
about,
9.
what about interest? What about interest?
In interest also it will be paid. I think interest has been paid. Interest no. Only these two things have been highlighted in my
Where is the DO?
DO Kotak is there. Action card.
So you were the sanctioning authority.
Yes, he is the drawing and disbursing authority.
So you had to sanction.
Sir.
I recently joined 3 months back, sir.
All right, so therefore you will not be punished, your predecessor will be punished,
Sir, I will comply. with-
whether he is here or not,
The
whether your
predecessor-
predecessor is here or not.
No, your lordship has directed the Puri DOs to come, all Puri. Cuttack DO is not a part, that is also a very peculiar thing. He has not implemented the DO.
Where was he posted? Where was he posted? Your client was posted
It
where?
was posted in Cuttack. In
Why have you included DO Puri as party? Huh?
Sorry, my lord.
Unnecessarily you
and all the DOs are
have
present.
troubled all of them.
Sorry, my lord. Not implemented.
My lord, we will comply with
All right.
1 week, he is saying.
It is.
Only differential amount is 1,000.
Counsel for the petitioner admits that in the present contempt application, the DEO Puri has wrongly been implemented as a contender. The contempt proceeding stands dropped accordingly.
My lord, the personal appearance,
Just in view of the fact that the petitioner had wrongly implemented the officials, the district education officer Puri in his individual capacity as a contender, considering delay in compliance of this court's order, the court had directed personal appearance of all the district education, all the persons who were holding the position of district education officer from the date of passing of this court's order
till date.
dated. What is the date of the order? Dated so and so. Dated. What is the date of the order? 14. Dated 2/9/2014. So in such view of the matters, the present contempt proceeding is dropped. Stop. It is, however, noted that an affidavit has been filed by the district by the district education officer Cuttack, cut off from which it appears that this court's order dated 2/9/2014 has been substantially complied with. Stop. The petitioner has been paid the arrears of salary and a sum of rupees 32 lakh has been paid to him.
32 lakhs, more than 30. 32 lakhs, 31,630. Recently he has.
32 lakh
32 lakhs, 31,630.
has been paid to him against the arrears of salary and
Area of
area of pension and area of pension and
salary received since long. This is 32 lakhs.
all right. Whether you have paid the interest, you somewhere it is mentioned in your affidavit.
Yes, it's, and interest part has not been paid. Perhaps you will pay. Interest.
Sir, 8% interest, it will be calculated as per the instruction of the government
Negative.
and will be paid in 1 week, sir.
The district education officer Cuttack, who is personally present in court, has assured this court that the petitioner shall be paid his entitlements in compliance with this court's order dated 2/9/2014 within shortest possible time. Stop. Next. The personal appearance of the officials,
All the DEOs. put.
all the district education officers. No. So give your names. Please give your names.
Yes, we will provide the names.
Don't do this. Do you understand what happened because of your wrong implement?
My lord, many DEOs are retired and they have come after retirement, they have been noticed to appear.
Just think of. There must be they may have valid complaint against the court. Then why were they called? Sorry. All right. Yes.
Item number 2.
May I please your worship? The order dated 21/3/2022 has not yet been implemented, longer. The last occasion we have time and the personal offense is there.
Yes, where is the order?
Order is mainly in the contempt petition. May I read my note? Considering the limited nature of grievances, this court disposes the petition with a direction to the opposite party number 1 to consider the specific direction issued by the tribunal in OA number 4279 within bracket C of 2013 and also consider the claim of the petitioner in light of the judgment delivered by this honorable court. Further, the final benefits as would be determined by the authority as due and admissible to the late husband of the petitioner shall be sanctioned and disbursed in favor of the petitioner within a period of 1 month thereafter. The entire exercise shall be completed within a period of 3 months from the date of production.
Yes.
Even after disposal of the first contempt, we have not yet even completed.
First contempt. Yes.
So, Lord,
Yes.
the SLP was preferred against this order, your lordship. After dismissal of the SLP, the file has been processed and it has been sent to the chief minister's office for concurrence for
When
implementation.
was the SLP dismissed?
It was dismissed on your lordship.
Eleven
11/8/2023.
So you are liable.
Your lordship, instructions from the government that they have sent it to the chief minister's office for concurrence for implementation of the order, your lordship.
With the person will have to be.
Given your lordship for compliance, your lordship.
No, what were you doing after the disposal of SLP? Waiting for the contempt matter to be taken up.
No, your
Face it,
file,
whether he is present.
the secretary was supposed to be present.
Someone is present.
Design.
Who was directed to be present?
Anu Garg.
Principal Secretary, yes.
She will be present in item 5 also, your lordship.
Still be present at item 5.
5 also.
Because in this case,
No, whether in this case, the direction was there for person.
Yes, your lordship, it was there. We had intimated also.
it may pass over, my lord,
Pass over
it
for-
can be taken up along with 5.
Five.
In 5, 6, 3 cases.
All right. Yes, next.
Item number 3.
My lord, I would regret to submit that this is a case which arises out of a removal of a Khasman, my lord. It was filed in the year 2002.
Where is the order?
My lord, annexer 2 at page 70, my lord. 19, page 19, you can see that the KLC case was filed in year 2002, my lord.
No, where is the order which has not been obeyed?
My lord, that is at page 19, my lord, page 19.
Yes. What is the order?
But also directed that the Tahsildar
Please submit. My lord, I will be permitted to read. Petitioners have immediately prayer in as much as seeking a direction against the collector and the district magistrate Cuttack, opposite party number 2 for taking lawful decision on appeal of KLC Khasma lease case number 1084 of 2002. However, for no further loss of time and as the matter is already listed twice in the
You have seen the order. You are not required to read the order. So this has not been complied with.
my lord.
Yes.
an affidavit was filed, personal notice, by order dated 16/5/2024, your lordship directed the collector to appear in person in view of the fact that 2 dates of disposal are appearing in the affidavit. That's what the collector is appearing. And in fact, yesterday we have filed an additional affidavit that hard copy I have given them. From that, it would appear that in fact the petitioner failed to supply certain documents. And in absence of those documents, the Tahsildar disposed of them. What I submit now in the meantime, let the petitioner supply all the documents, we will pass the order.
No, but why these, or whether this order has been complied with or not. The court says lawful decision taking into account the recommendation, if any, to be available at page 20 of the brief within a period of 2 months. So you are not required to get any document. You are just required to pass an order.
That is approval.
So, approval we don't know. They will take a decision.
My lord.
You are required to take a decision. That decision has yet not been taken.
The decision has been taken.
Then the matter is over. Where is that decision?
Yes. That is at page 14, annex to E.
Have you given him a copy?
Yes, today I am giving
Page?
page 14, today's affidavit.
Just a minute.
Annex to E, page 14.
Yes, that has been disposed of.
Yes.
My lord, I am submitting, my lord. Your lordship can see, honorable court also,
The court has done nothing.
my lord,
Court has
same solution was advanced before my lord, Justice Rautar, my lord. But it was not accepted as because your lordship can page 13, running page 13, my lord.
all right.
That is the order of the Tahsildar. You have submitted the entire Khasmal case record before the collector, my lord, on 7/6/2010, my lord. That is, I am just reading the operating portion, my lord. Case record is,
Sorry, we will not. I will not proceed.
my lord, Tahsildar can be contempt petition, my lord, my lord. That is the order of the Tahsildar.
See you.
I am not supposed to submit any document as per my understanding, at page 14, my lord, you know, see, I am not supposed to file any document, my lord. Annex of 1, my lord. Annex of 1 at page 14, we kind of have a glance, my lord. That is clearly mentioned that the Lord Tahsildar has submitted all the case record after the inquiry and the completion of the entire process. My lord, he submitted only
No contempt is made out. You can challenge the order.
my lord, it was made for only approval of the collector. My lord, as required, I'm citing a decision of this court also, division bench decision. I'm not the original dissimilar. I'm not the original, I'm the professor.
We are in contempt jurisdiction. We
My
cannot
lord.
go into the merits of the case. The court is just required to see what was the order and what has been done. What has been done may be illegal.
Nothing has been done, my lord. Nothing has been done by the collector, my lord. Today. Nothing has been done, my lord. No communication has been made by the collector.
23,
My lord.
14 to 2023 order. This has not been done anymore.
No, my lord. Not at all. I have not received any communication from land collector, my lord. That is why I am submitting.
The petitioner has raised disobedience of an order of this court dated 5/9/2022, which reads as under. Also, next, first of all, affidavit has been filed on behalf of the contenders, bringing on record an order dated 14/2/2023, passed by Tahsildar Katak in which case?
As
Case
far as
number is
case
mentioned.
number,
Where is the case number mentioned?
KLC number 1084 of 2002.
No, where is that mentioned in the order?
That is page 19 of the contempt application. Third line.
Sir, in the order, where is it mentioned? How do you say that this order has been passed in this KCL number 1084?
But the order was, honorable court directed the collector to complete the process. But instead of any communication to the petitioner,
Passed under the signature of Tahsildar Katak. 24/2/2022 or 23?
23, madam. 14 to 23.
No, stop. The said order does not reflect that the same was passed in KCL number 1084 of 2002. So stop. Next, learned counsel appearing on behalf of the who was opposite party number 2 in the petition?
Opinion number 2.
So what action should be taken against you? Because you don't know who is opposite part number 2?
Sorry, madam.
And you want action against the district magistrate?
the opinion number 2 is, my lord.
The petitioner has submitted that the said order dated 4/2/2023 has not been communicated to him.
Collector.
Just a minute.
Collector.
Has not been communicated to him. And in any case, the said order has not been passed by the Katak. The district by the collector Katak, who was opposite party number 2 in the writ proceeding, and was required to pass an order in terms of the court's order, violation of which has been alleged. Stop. Next. The You are Collector Katak.
Yes.
Collector Katak is present in court physically. So place this matter on 2 weeks. But I'm of the prima facie view that this court's order dated so and so has been complied with, with the passing of the order dated 14 to 2023. So stop. However, in strict compliance of this court's order, if any order is required to be passed by, was required to be passed by the collector, he should have passed an order. Stop. However, such disobedience does not appear to be deliberate, prima facie. Stop. Let's this case on 2 weeks. Stop. In the meanwhile, the collector Katak shall be required to pass an order as directed by this court, as was directed personal attendance of the collector. The collector Katak shall not be required to be present if in the meanwhile an order is passed.
Item of 4. If I may please be worship number. But there are 2 contempt applications. Now let me kindly have the first contempt. The relevant part directions are there at page 10, paragraph 5.
Just a minute.
Your Lordship.
Yes.
Considering the rival contentions of the parties, this court finds once a benefit has been conferred on an employee by virtue of an office order, unless it is absolutely illegal and passed mistakenly, it cannot be recalled without following principles of natural justice. Further, looking into the letter of Mr. Saha issued on this court finds this letter was issued based on a complaint or information of one Mr. B.B. Hota, who even has an endorsement.
What is the?
Yes, it starts thereafter. This court takes into account the submissions of the learned counsel for the petitioner that this Bhagavata ultimately became the beneficiary of the benefit withdrawn from the petitioner, which remains undisputed by Mr. Patnaik. From the document at Annexure 5 to the counter taken support in Annexure 6, this court again finds this document has again the endorsement of Mr. Hota. It became the subsequent beneficiary. There remains no doubt that Mr. Hota has not been paid. This amount that was way back in the year 1998 that has not been done, my lord. We have the second contempt application that has also relevance with this application, because this court has directed that all retirement benefits are within a period of 1.5 months. That direction is there in the next contempt. May I kindly have it? The relevant part starts from page 20. It has.
Yes.
In this view of the matter, this court finds the show cause notice is given person not maintainable. As a consequence, while declaring the show cause notice, wide annexure 1 remains bad in law, this court observes, as per the view already taken on the matter, the report is prepared. The report involved here is also not sustainable in the eyes of law. This court finds, while entertaining the writ petition by order dated 18/10/2000, this court had already directed that the disciplinary proceeding initiated against the petitioner may continue, but there shall be no final decision, which order is in operation as of now. In the circumstance, this court, while setting aside the show cause at Annexure 1 and the inquiry report enclosed, allows the repetition. It is at this stage, considering that the proceeding was initiated in the year 2000 and the petitioner was aged about 46 years old in the year 2000, having attained the age of superannuation since long, and there is no possibility in continuing with such inquiry. There is also no possibility of punishment, considering that the petitioner has already attained the age of superannuation. In the circumstance,
petitions while setting aside the show cause notice by Annexure 1 and declaring the inquiry report as barred in the eyes of law, this court directs the Utkal University to consider the case of the petitioner for retirement benefit. Benefit of the petitioner on superannuation if not clear be calculated and paid in favor of the petitioner by undertaking the entire exercise within a period of 1.5 months from the date of the communication of an authenticated copy of the order by the petitioner. The petitioner will also be entitled to interest at the rate of 5% all through. May I kindly have the rejoinder, my lord, that I filed in this?
No, whether this order has been complied.
No, my lord, my respectful submission is still that it has not been complied. My lord, what they're saying is now the period of suspension is being treated as such. Despite the findings of this honorable court that no punishment could have been imposed. My lord, this, the university authorities are sitting on appeal of the orders of this honorable court. So, my lord, that is what I say is cannot be done. My lord, when the retirement benefits were directed to, it included all the period of salary that is not paid and to be accordingly calculated the notional benefits. My lord, now what they have done is they have given up him a notional salary of 22,000. I had made a submission and the tabulation before this honorable court, which they were directed to give a tabular reply as to why it has not been done. But that period also has not been done. My lord, I respectfully state that once the show cause notice and the other inquiry report is held to be bad in the eyes of law, the period of suspension could not have been treated as such. So, passing an order after the Honorable High Court has passed an order that no punishment could have been imposed.
All right, all right. Yes.
So, may I submit my notes? I have already, my please to go through this order, the operating portion of the order. Retirement benefit to be extended. With due immunity managers, the university has extended that retirement benefit and managed final draft to the last affidavit filed.
No, have you extended because there is nothing against it.
But we have extended the retirement benefits.
We please understand.
Yes.
There was nothing against him. The so-cause one order was interfered with because there was violation of principles of natural justice. Your so-cause notice was set aside. So there was no proceeding against him. Now he was to pay everything as if there was nothing against him.
There minutes I have a small submission. First, I would like that order once again minutes I am placing it. All the returns passed, all the retirement benefits to be extended. So far that salary component, all this thing, and the court has not decided this. Now my learned friend says that it should also have been paid, and it should be considered that it should have been paid. The university is extending the retirement benefit because each of the scheme retirement benefit. That point was argued kind of that's the last order.
So why have you withheld salary?
7% that has not been done because the thing was that the government court's direction is to pay the retirement benefits. The retirement benefits have been extended. What the learned friend says.
You are right. You may be right. So when did you? When was the order passed?
That's the order was passed last year. That was on 17/9/2021.
17/9/2021.
Because there was
And within what time pension was required to be paid?
pension is not entitled to gratuity or the retirement.
Whatever retirement benefit.
So gratuity.
Whatever retirement benefit was to be given. Was that given?
That already was I have given the so-cause that was paid my last. That is on 17/9/2024 at Annex A 2.
17/2024 after 3 years.
3 years we did.
All right. All right. Yes. After 3 years you paid. All right. All right. So
Thereafter,
just
I am sponsored.
just a minute. And within what time you were required to pay?
That stipulated, that is 1.5 months. 1.5 months.
1.5 months. So the contempt is made out.
Yes, contempt is my.
No, you don't beg apology. You are unnecessarily harassing him.
No, there are some one thing.
You don't see. You will do everything once you are punished.
Thing is that
That since you are becoming technical, the court is also becoming technical. Because in 2021, the order was to be complied within 1.5 months. You have complied within 3 years. You took 3 years to comply with the order.
what my says is correct in that respect, which means one thing. The order is that what it will not be one another when pay 6 months 6% interest. Ultimately, all these things were paid. When this matter was independent, but it's not independent, it is
The court is just warning you, your client also, that whatever is entitled to must be paid. And if that is not paid on the technical ground, that was not in the order, then we have the scope. Because contempt is made out. Why a person has to apply, make an application alleging contempt of court? And this matter is pending since 2023. You have the option. You have the option. Either he should come to the court with a submission that nothing remains to be paid to him. Otherwise, you face consequences.
There must stand in my constitution only one line minutes.
Yes.
One page only.
Yes.
My standard was my affidavit 25/2024 minutes, compliance affidavit. 28th May 2024 minutes.
See, choice is yours. Choice is yours. Either take a defense or do what is legal. So if you take a defense, we will.
I want that one. In my mind, I understood that. That is not that I'm not understood.
I will be happy if you can defend yourself.
No, Master, things are going in a different manner. I understood that.
Things are not going in a different manner.
Not manner.
Yes.
In the different context, I understood. I appreciate that. But I understood that. I am coming with it. It's not because I am standing in the road not that much. I am because they are not entitled. So I am conscious of my position and everything entitled to one part. That happened as we last year, and what is the argument and what is the thing I compared with. That will be that is what marriage.
No, I will not see anything. I will not see anything. If you want me to see anything, I'll see everything.
Yes.
So the choice is yours. Take a decision whether you are taking a defense or.
The thing is that they would be entitled to salary for a whole total period.
I don't know. I don't know. See, therefore, the court is observing that since there was nothing against him, no departmental proceeding, nothing, so he was entitled to everything. You say that because of the direction, you have paid only pension, and for other things, you will have to come to the High Court. No. You are saying that let him come to the High Court.
No.
This is what you indicate. Indicate means he will not pay. If you don't pay, then what will he do? Whatever. So if you take a defense, pay a charge and I am initiating contempt.
Some time so that I will see
2 weeks, not more than 2 weeks. If you do everything, it's all right. Otherwise,
it's all right, my space.
Because as requested by learned counsel representing the contemners, the matter is adjourned to 2 weeks, when the court will consider, based on the stand which has been taken in the so-called affidavit as to whether a case of deliberate disobedience of this court's order is made out because of delayed compliance of the order. Most of it goes without saying that while considering as to whether the court should proceed against the contemners or not, it shall take into account the contempt, the conduct of the contemners subsequent to passing of the present order.
My lord, may I just make a prayer? My lord, on the last occasion, the lordship was pleased to put it in the top 5 matters. Let it be there.
Oh, yes.
I'm grateful, your lordship.
Title of 5. Latest order dated 6/1/23 has not been complied with my lord. And this is my lord, 47, my lord. The operative portion is in view of the aforesaid analysis and further taking into consideration the peculiar fact and circumstances of the
Just a
case.
minute, where is the order?
My lord, order annexure 6, my lord.
Annexure 6, just.
Annexure 6, running page 47, that is the operative portion. Order dated 6/1/23, my lord, para 11. In view of the aforesaid analysis and further taking into consideration the peculiar fact and circumstances of the case, this court grants a last opportunity by directing the contemnor to comply with the direction of the tribunal as confirmed by this court as well as the Honorable Supreme Court within a period of 3 months. Hence, in view the order passed in case of similarly persons, Chaitanya Gowda and others. Accordingly, service benefit as is due and admissible be calculated.
Election.
Yes, madam. That was, this order was passed after on hearing of the second content, my lord. The SLP of
What was the direction in the writ petition?
read petition, my lord, that was the order of the Lawrence Tribunal regarding regularization and payment of pension that was passed in 99 under Annexure 1, my lord. That was confirmed by this honorable court and then their SLP was dismissed on 5/7/18, my lord. Thereafter, this petitioner filed one for implementation of the order after abolition of the tribunal, my lord, under Annexure 2. In that case, this honorable court granted 1 month time, my lord. They did not comply, then first contempt and then second contempt. In second contempt, they have filed one compliance affidavit that was dealt with in this order, my lord, 6/1/23, that without regularizing in the post of mechanic grade 2.
So where is the order passed by this court, violation of which you are alleging?
Yes, Annexure 6, run order dated 6/1/23, my lord.
So this order was passed in a contempt case.
Yes,
Where is the before, that was the first contempt.
that was second contempt.
So this is third contempt.
Yes, this is the third contempt.
So, but where is the original order?
Original order is the original of the order of the tribunal, my lord, kindly see. Annexure 1. Annexure 1, page 12, my lord. That is the order of the Lawrence Tribunal. And this petitioner is Govind Sahu, that is OS 620 of 99. Para 3, the applicant in OS 620 of 99 joined in service as mechanic grade 3, 64 in
This is the order.
my lord.
Yes, what is the matter?
My lord, petitioner approached the tribunal in 1999, claiming that he be brought over to the regular establishment from work charge establishment. Now the tribunal directed that he is to be regularized in any post in the regular establishment
Only for the purpose of pension.
only for the purpose of pension and other benefits.
Yes.
Now challenging that order, we approached this honorable court in OJC in 2000, my lord. Now that writ petition was dismissed. In 2017, we approached the Honorable Apex Court. Honorable Apex Court dismissed the SLP in 2018. Thereafter, since there was no compliance, he approached this Honorable Court and the tribunal was abolished in the meantime. He approached this Honorable Court with a writ petition. Writ petition direction was given to comply with the order of the tribunal in letter and spirit. That was the direction. Then, due to violation of that order, a contempt was filed. Contempt was
Forget rest of the things.
contempt was disposed of.
When there was an order passed by the High Court.
Yes.
For compliance of the order passed by the tribunal.
Yes,
after the matter was dismissed by the Supreme Court,
yes.
then why did you not implement that?
But already we implemented that, but he was regularized in the post of peon in the regular establishment. He again filed the contempt petition alleging that I was a grade 2 mechanic and I should not have been regularized in the post of peon. That was the allegation made.
Let me see the order again.
Your lordship. I'll take your lordship to page 40 of the contempt petition. Page 40.
Yes, where is the violation, Mr. Counsel? Where is the violation of?
And now the violation, annexer. Now in the meantime, after filing of their last order passed by this honorable court, we have filed a compliance affidavit. He has been, the post as a supernumerary post in the grade 2 mechanics has been approved with due concurrence of the finance department as well as the.
What else do you want? What has been given to you, you might not have been given had the matter been taken up by me earlier.
No, they undertake to.
Where is the question of undertaking? Come to the order.
Yes, order.
The tribunal.
That was dealt with in the content application, my lord. Thereafter, direction was given to implement the order of the tribunal.
See the order of the tribunal.
Yes, my lord. So kindly, annexer. Yes, my lord.
The
Operative person, annexer 13, my lord.
petitioner had approached.
Annexer 30, sorry, PS 30, para 6. I direct.
Understood.
Yes, my lord. Thereafter, my lord, what happened? After in the similar circumstances, with respect to identical order, my lord, what were same in Chautanya Gaura case, my lord.
Counsel, the order is, I direct that the applicants be absorbed in any establishment post from the time they completed 5 years. So any establishment post.
Yes, my lord.
So you have given.
No. My lord, kindly see, annexer page 13, my lord. Identical order, same order.
This to be withdrawn.
No, my lord.
The
No,
decision which they have taken.
No.
Withdrawn.
no, let them comply, my lord.
That compliance affidavit.
The copy will be given.
Yes. Was e-filed yesterday, but somehow.
So you accept it.
No, I just now I received it.
Only. Compliance affidavit.
I will
has
also
been
instruction.
on behalf of the.
My lord, the
members. Stop.
secretary is present through VC. my lord.
Secretary. The additional chief secretary. Which department?
I don't know the secretary is present through VC.
Personally, he has joined the proceedings online. So, following was the order passed by the Odisha Administrative Tribunal on 19/4/1999, paragraph 6. Violation of which has been alleged in the present contempt. First, alleging disobedience of the said direction of the tribunal, comma, after the tribunal was abolished, the petitioner had approached this court by filing a writ petition giving rise to OJC number 7024 of 2000. Stop. The said writ application was disposed of in following terms, page 17, Land Council for the petitioner, 17, page 2. Stop. The alleging disobedience of, it is not in dispute that the petitioner, when was he absorbed as PM?
My lord, 14/7/2022, page 26, annexure 4.
The alleging disobedience of this court's order, the petitioner filed you filed another writ petition.
My lord. No, my lord. While pendency of the contempt, second contempt, my lord, they have filed that compliance that we have regularized in the post of peon.
This is what I am asking. When was he regularized as peon?
Regularization in the post of peon, that was on, my lord, by the order 12/2022. Annexure 4, my lord. 14/12/2022.
And that is also dealt with in that order, 6/123 order,
6/123 is contempt.
contempt, my lord.
The fact remains that only for the purpose of grant of pensionary benefits, in the light of the direction issued by the Odisha Administrative Tribunal, he was absorbed as a peon in which establishment?
In the regular establishment as post of peon.
Where?
But that is engineering.
Under SC Earth Dam Division, Chitrakonda.
Executive Engineer, Earth Dam Division, Chitrakonda.
It was, however, it is the case of the petitioner that he ought to have been absorbed against which post?
Grade 2 mechanic.
Grade 2 mechanic. Stop. Next. So, there was no such order passed by the Odisha Administrative Tribunal requiring petitioner's absorption against a grade 2 mechanic post, comma, it has been stated in compliance affidavit filed on behalf of the contemners that decision has been taken to absorb the petitioner notionally against supernumerary grade 2 mechanical
Grade 2.
post apparently for the purpose of grant of pensionary benefits
Pension value.
only. Stop. In such view of the matter, in the court's opinion, no case of deliberate disobedience of this court's order is met out. The contempt proceeding,
Now, there is also direction to pay all the dues.
they will be paying.
The direction, because original order, there is direction to pay all these dues.
They will do it. We will not say anything. The court will not say anything. And don't make the court to say anything, because even if they had not issued this, I would not have proceeded further. Yes.
Your Lordship, the secretary is here for item number 2, Your Lordship.
Item number 5, since there was a direction for personal appearance.
Personal
like that.
appearance, dispense with.
Yes.
Yes.
Item number 6.
Filed the local reply, my lord. The Lawrence Secretary's order, my lord, was challenged recapital, my lord. Thereafter, the recapital was dismissed. The state has filed the SLP, my lord. Lordship, page 7 of my so-called reply. The delay was under a notice of issue, my lord. The SLP is pending, my lord.
Yes.
I've just now received that.
So no, we cannot proceed further.
Your Lordship, kindly see their compliance in this contempt petition. File the compliance on 1/5/2024 in this contempt. Compliance affidavit filed. In the compliance affidavit, page 7, annexure A/4. What they have stated.
What?
The Honorable Irrigation Manager, Sri Rajkishore Sutar, Carpenter, retired on 30/6/2003, year of the sanction.
Where are you reading?
Provisional pension. Then, my lord,
Where are you reading?
page 7 of the compliance affidavit dated 1/5/2024. 1/5/2024 of the compliance.
Lordship, can I see page 7 for a moment?
Page 7.
Page 7 of the.
The delay was condoned and notice was issued by.
Yes, how?
I am just a 1/5/2024, they are compliance affidavit in contempt. But they are submitting now. What I am submitting, my lord.
Mr. Counsel, there is an order passed by this court. You are alleging disobedience of the court. They have challenged the order which is pending before the Supreme Court.
My lord.
So it is not that they have deliberately violated the court's order.
I am not saying so. What they have stated in the compliance affidavit in this contempt petition on 1/5/2024. Thereafter, then your lordship kindly order of this on the court on 17/4/2024. 17/5/2024. The superintendent appeared in person before this court, my lord.
But they have filed SLP.
Oh, yes, my lord, they are finalized, but they contended that, they directed him to release the concern from 1/7/2023, but they released the provision concern from April 2024.
The entire matter
They contended in before your lordship in person by saying that the provision, the opinion number 3 in person.
Please
Directly concern.
he might have been advised
Yes, my lord.
that don't implement the order, go to Supreme Court.
Supreme Court for final concern, not for provisional concern. Order, the AC direction is to release the concern.
Petitioner.
Thereafter, question of provisional concern, they are not paid.
This
The
court
personally appear in contempt of that.
23 passed in WPC OAC number 123 of 2009. First off, a compliance affidavit has been filed on behalf of the estate, wherein it has been stated that this court's order was challenged before this court in WA number 1838 of 2023, which came to be disposed of on 15/11/2023. First off, the said order of this court dated 15/11/2023 has been challenged before the Supreme Court, giving rise to SLP civil number SLP bracketed civil diary number 14869 of 2024, in which the Supreme Court, after having condoned the delay, issued notices to the parties. So, a copy of the Supreme Court's order dated 6/5/2024 has been annexed in the affidavit. So, since the this is the order of the court, violation of which has been raised in the contempt application, is subject matter of challenge before the Supreme Court by the contemptors, in my opinion, no deliberate disobedience of this court's order is made out. First off, the contempt proceeding is dropped. Yes.
Item 2.
Item two, your lordship, the secretary is here online, your lordship.
Yes. What happened in item 2?
Order dated 21/3/2022 has not yet been implemented in spite of dismissal of the SLP in 11/9/2023.
Yes. Where is the order?
Order on annexure 1 of the content petition, my lord.
What is the order?
My lord, considering the limited nature of grievance, this court disposes the writ petition with a direction to the opposite party number 1 to consider the specific direction issued by the learned tribunal in OA number 4279 of 2013, and also consider the claim of the petitioner in the light of the judgment delivered by this honorable court. Further, the final benefit as would be determined by
This has not been done.
no man.
Your lordship, we had, before the SLP challenges order in the SLP, it was dismissed. And now we have processed the file, Your Lordship. It's with the Honorable Chief Minister for concurrence, Your Lordship, for implementation of the order.
Oh, but this order was passed when? 2022. When was the
23, Your Lordship. The SLP was dismissed on 11/8/2023, Your Lordship.
Then we are in 24. Well, so by what time, madam? How much time will it take? How much further time will it take? Madam,
I think she's been muted.
Yes, sir. Sir, good afternoon.
please, how much further
Sir,
time?
sir, just 15 days. It's with the Chief Minister. We will get it done.
As the Additional Chief Secretary, Water Resource Department.
The water
Yes.
is-
Water resources.
So the Resource Department has joined proceeding online. First off, the court has been informed that the court's order violation of which is under challenge in the present contempt application or subject matter of challenge before the Supreme Court. So the special leave petition is said to have been dismissed. Stop. The Additional Chief Secretary has assured this court that this court's order shall be fully complied with within 3 weeks. So place this matter on 3 weeks. If the person's attendance of the Additional Chief Secretary shall not be required online, or if in the meanwhile the order is complied with.
Thank you, sir.
Obviously.
Where is the order?
Order on the Annex 1, page 7.
এটা কি হিমসার পাচ্ছি হিমসার আমি নোটে যাই
না, second. As per judgment, at page 8.
There is nothing in the order.
You can see the page 8, the judgment.
Page
As
8
per-
or 7.
Page 7 is the order. First, as per the judgment, that was 11/8/2022, page 8, Your Lordship. Similar in nature, sir. The operative portion is page 19.
Read paragraph 5.
Mr. J.P. Karna, lawyer advocate, contended if similar matter has already been disposed of this by court, the disposition may be disposed of in terms of the observation or direction given in the said petition. Your Lordship, the petition disposed of in page 8.
If similar matter has already been disposed of by the court. So that is if
Yes, Miller. Similar matter.
this
disposed.
petition may be disposed of in terms of.
Yes,
So it is yet to be decided whether a similar matter. Yes, what is your stand?
this is the similar matter, but similar direction was to operate particular two. They have separate council, they have separated the Bhimsar, they have separate council. We are not appearing, state council is not appearing for Bhimsar. Notice may be
Alright.
issued.
It's a notice. But how could he? Vimsar was noticed
no notice was issued.
in the writ petition.
Is in it with some, as per the judgment on page 8, Your Lordship.
Mr. Counsel, the judgment was not there. This order, Mr. Patnaik was not appearing for Vimsar.
Your Lordship, kindly see page 19 for a moment.
Yes.
Sir. Page 19, paragraph 19. Nimsar was opposite party number 2, Miller.
In the other case, but in your case,
In our case, Nimsar was party. In similar matter, page 19.
but Vimsar was not noticed.
But it was direction for consideration, Miller.
Then.
Page 19 for a moment,
Very
thanks.
difficult, very difficult,
Page 19.
very difficult.
Page 19, paragraph 19.
No, sorry.
What you can see the for
See,
consideration.
Mr. J.P. Patnaik did not have any right to contend on behalf of himself.
There is direction for consideration, Miller, not direction
Direction for
content.
consideration.
Page 20, it is directed to opinion to
Sorry. The petitioner alleges disobedience of this court's order dated 1/11/2022, passed in WPC number 26596 of 2021, which reads thus. First off, next, in the said writ proceeding, Vimsar means what?
Bureau Sulelasai Institute of Medical Science and Research.
Was a party. And direction against Vimsar was sought. And counsel appearing on behalf of the petitioner had referred to this court's decision dated 11/8/2022, passed in WPC number 24687 of 2021, to contain that the petitioner's case is squarely covered by the said decision. And accordingly, the respondents ought to have taken a decision in the light of this court's order dated 1/12/2022, passed in WPC number 26596 of 2021. Stop. Next, it is, however, an admitted fact that in WPC number 26596 of 2021, the Vimsar was not noticed. Stop. No one had appeared, no one had represented Vimsar in the said writ proceeding. Stop. Mr. Submission of Mr. J.P. Patnaik, learned government advocate, as recorded in the order dated 1/12/2022, could not be treated as submission on behalf of Vimsar. Stop. In such view of the matter, in the court's opinion, no deliberate disobedience of this court's order is made out. Stop. The contempt proceeding, I am not inclined to proceed in the present matter, in the present contempt proceeding. Stop. Next, it goes without saying that the petitioner shall be at liberty to approach the appropriate authority under Vimsar to seek his claim, or approach appropriate authority, appropriate forum, by making appropriate forum in accordance with law. Yes.
God bless. Item number 8.
Dispose of.
Item 8, the Lordship kindly see the last order dated 28/6/2024. The last order.
Just a minute.
Copy the dates. As you can read it.
28/6.
Madam. 28/6/2024.
Yes. So read the order. Just a minute.
Order is at Annex 1. The relevant portion is at page 9 million. Para 7.
Annexure.
Annex 1 to the contempt.
Page 9.
Page 9 million.
Yes.
Para 7.
Yes.
Having heard long counsel for the parties and taking into account the fact that the order passed by the tribunal under Annex 2 has been confirmed by this court while dismissing the petition by the order at Annex 3. This court, while disposing of the petition, directs the opinion number 2 applicable part number 2 to comply with the order so passed by the tribunal under Annex 2 within a period of 3 months from the date of receipt of this order.
Yes.
So this order was challenged by the state functionaries before this honorable court in division bench. And this honorable court in division bench held that the order passed by the Language Tribunal was justified. But so far as financial benefits are concerned, the modalities were fixed as per the government instruction dated 7/5/2008. So let's not kindly peruse the order of this honorable court in division bench. For a moment.
Where is that?
This I am. So,
LRC can find it from my so-called affidavit filed today.
Whether the order has been complied with or not?
Yes, my lord.
and they have complied, Miller. What they have done, the honorable division bench of this court, while confirming the order of the Language Tribunal, hold that I am entitled for the benefits of my financial benefits as per the government notification dated 7/5/2008, Miller. So in the worst case, the tribunal has directed to give me it from 2015, from the date of filing of the case, Miller. So I filed the case in the 2015. So they could have given it to me from 2015. But this honorable court in division bench hold that I am to get the benefit as per the government instruction dated 7/5/2008, Miller. And in that the circular, let me kindly see the.
So where is the order of the division bench?
My melody LRC, I have filed the so-called yesterday. LRC, you can find it, my so-called filed on yesterday. Page, there.
I have handed over the question. Kindly process. I have handed over to my.
Or I am submitting the hard copy only.
The order of this honorable court. Page 19 of that so-called requirement.
Page 19.
Page 19, 19. This is the order of the honorable division bench. Para 7, I am relying here. Page 19. Having heard land counsel for the parties and after going through the records, the undisputed fact is that opposite part number 1 was appointed as fourth peon of the fourth post of peon against the clear court vacancy. His service since has not been regularized. The tribunal directed for regularization of the same in the order in. So far as the employment of fourth peon is concerned, the issue is no more res integra in view of the decision of the apex court in Rajendra Prasad Das case. As consequence thereof, the tribunal
Subsequent guidelines issued by the office order number 7/5/2000.
might.
You were entitled to. It is not that you were entitled to from 7/5/2008.
No, is in that guideline, let me kindly see what the modality has been fixed. It has been quoted in the very next page 20. Page 20 of that order, Miller. Page 20 from the bottom, the adjustment shall be prospective in nature and the aforesaid so-called fourth peon so adjusted is entitled for salaries only after he or she resume duty in the said post, Miller. So, if this will be taken into consideration, I have been appointed and continuing from 1993, Miller.
So that you can raise in a
Yes.
separate proceeding, not
Once,
Miller?
here. That issue you can raise in a separate proceeding, not here in the contempt proceeding.
They file a complaint, sir, regulation kind of see. The complaint
That
affidavit.
aspect, Mr. Counsel, that is a different thing. That is completely different issue. You can.
For a moment, there was no kind of a complaint affidavit. Where they have done, Miller, yes, Miller, the complaint affidavit filed in the last day. How they have played, the authorities have played mischief, because Miller, I have been continuing from 1993. There is no dispute. Just before 15 days, the headmaster has sent the proposal to the DA, the district education officer, that I have been continuing from 1993 onwards against Miller. But the day the order was passed, complaint affidavit, let me kindly peruse for a moment. Complaint affidavit, page 6, annexable 3.
When were you adjusted?
From the last month only, Miller. from last month only. I'm reading the complaints affidavit, what they have done. Pursuant to the order dated 24/5/2019 of the Learned Tribunal.
Then we cannot go enter into that dispute. See, come to page 20. Come to page 20. In the present proceeding, the court cannot decide that you are entitled with effect from 7/5/2008 on any ground. Because it simply says adjustment shall be prospective in nature. Prospective in nature means from the date of adjustment. All right.
Yes, ma'am.
And the aforesaid so-called fourth peon so adjusted is entitled for salary only after he resumes the duty or post. So after adjustment.
I have been adjusted from 1993, not from this last month, Lord. I have been adjusted from 1993 and I have been discharging my duty in that post, Lord. So if that person will be taken into consideration, Lord, then they will get my benefit from 1993.
You can challenge that. You can take, will give you liberty. The petitioner has alleged in the present contempt application the disobedience of an order dated 17/5/2023 passed in WPC number 13966 of 2023. So soft. By an order passed by the Orissa Administrative Tribunal in OA number 2395 of 2015 was sought to be implemented by filing the said writ petition, that is WPC number writ petition. So stop. The writ petition came to be disposed of by the order dated 17/5/2023, operative portion of which reads as under. So stop. Next, learned counsel appearing on behalf of the petitioner has submitted that the petitioner has been given the benefit of adjustment as fourth peon
From 13/6/2024.
from 13/6/2024. Whereas, in terms of the said order of this court, he was entitled to be given such benefit with effect from 7/5/2008. Stop. Next. Since it is an admitted fact that in compliance of this court's order dated 17/5/2023, a decision has been taken and the petitioner has been adjusted against fourth.
Not adjusted, they have approved. I have been adjusted from 1993, but they have approved. So what do you
Approved what?
For a moment, I'm reading that portion, Mother. Also to consider the case of petition prospectively by the order so and so, the appointment of Sri Kamalakant Ghosh as peon in RN Academy, Sarswatipur is hereby approved prospectively from the date of from the date he actually joined in the post, Mother.
Petitioner. From the date he actually joins. Stop. Next. Since in compliance of the said order dated 17/5/2023, decision has been taken. I do not consider it to be a fit case for proceeding further by initiating contempt proceeding. First off, the disobedience cannot be said to be deliberate. First off, it goes without saying that the petitioner shall have the liberty to approach appropriate forum in accordance with law.
My lord, personal appearance of DO may be dispensed with.
Law
It's
for
on line.
law to establish his case that he was entitled for benefit with effect from 1/7/2008. What is that date?
7/5/2008.
7/5/2008. In accordance with the guideline dated 7/5/2008. First off, the district education officer Balasore has joined the court proceeding online. Her appearance stands dispensed with.
Item number 9. But here, the petitioner was working as an work on a workers establishment, my lord. My lord, for around 30 years. And despite law,
Where is the order?
my lord, the order is at annexure 1, my lord. The lordship will find. I will take your lordship's kind attention to paragraph 6 onwards, my lord, which will be relevant for your lordship's purpose, my lord. In course of his argument, learned counsel appearing for the petitioner also referred to the order passed by this court in Sadananda Seta versus so and so, so and so. He also replied. He also relied upon the order of this court by a coordinate bench of this honorable court. In the case of Arkit Sahu versus State of Odisha, in so and so decided on so and so. On careful analysis of the judgment, this court is of the view that the judgment of this court relied upon by the learned counsel for the petitioner has been delivered by relying upon the law laid down in Narsu Pradhan case.
So whether any decision has been taken?
But here we have already filed a writ appeal with a delay of 106 days. And the honorable court has been pleased to issue notice in that writ appeal. my lord.
No,
So you
please to issue notice on the question of litigation.
here,
It was passed in what has happened, my lord, I will just, my lord, refer to the dates, my lord. The order was passed, if your lordship will kindly refer to, my lord. The order was passed on 27/3/2023, my lord. Directing them to comply the order within a period of 2 months, my lord. They didn't comply. My lord, I filed a contempt application. Their extension was granted, my lord. 2 months' time was again granted to them to take a decision. After disposal of that application, they filed a writ appeal with a delay of 106 days, my lord. On 9/10/2023, notices were issued. I have appeared in the appeal, but till date they have not taken any action. My lord, not taken any
we want
steps.
that matter to be taken up.
My lord, any day next week,
All right.
along with that, your lordship may call.
I will not proceed with the contempt matter.
My lord, this contempt petition, unless your lordship finds, my lord, the
Petitioner
petition is the same, around 80 years old man, my lord.
The petitioner,
My lord, who has been running to your lordship, my lord, on numbers of occasions, my lord, 4-5 occasions he has.
counsel, if the petitioner is old, 80 years old, then I can guarantee you that your appeal will be taken up in the next week if you want. All right. But the contempt petition, I cannot entertain because of the pendency of the appeal. The petitioner has raised disobedience of an order of this court dated 27/3/2023, passed in WPC number 6435 of 2023. So it is not in dispute that an appeal has been preferred against the state order passed by the intra-court appeal has been preferred against the state order passed by the learned single judge, giving rise to WA number 1913 of 2023, wherein notices have been issued on the point of limitation. So since the contemners have preferred a writ appeal, a writ appeal against the state order dated 27/3/2023, I am not inclined to proceed in the present contempt matter. Stop. Contempt proceeding is stand dropped.
What I was praying, my lord,
Yes.
your lordship will not keep this matter pending. My lord, after disposal of that writ appeal, your lordship can take up, because my lord, after disposal of the appeal also.
But what will happen in writ appeal? See, as
No, that
on
is clear.
Mr. Counsel, we are in contempt jurisdiction. We have to see the intention of a person. So that intention of the person can be seen through his conduct. His conduct is that he has preferred appeal. So,
Not appeal, but your lordship will find that law has been settled by the honorable apex court.
Right.
The lordship case, my lord, lordship Pradhan case, my lord. They have complied with lordship Pradhan case, my lord. Now they are challenging this order.
therefore, the writ appeal will be the writ appeal will be dismissed.
That is what, my lord.
So that is
What I expect, my lord.
should I record in the order that later?
No, my lord, that I
Make
think.
a mention, I'll take up, and that I'll take up because of your age. You are saying you are 80 years old. On that ground, I can take up your appeal on priority basis.
Your lordship
In
will
appeal.
direct the
You
office.
just remind me on Monday, whenever we are available, Tuesday.
There was a direction for personal appearance that may be dispensed
The
with.
personal appearance of so whose personal appearance?
The additional chief secretary.
Additional chief.
There is no direction. Personal
Yes.
appearance. Item number 10. Item 12, read the appeal has been filed and that has been stayed. WA number 621 of 2023.
The order of this court, the order passed by the learned single judge of this court, violation of which has been alleged in the present contempt application, has been stayed by state in an intra-court appeal by an order dated 21/4/2023. WA number 621 of 2023. Such view of the matter. No case of deliberate disobedience of this court's order is made out. Contempt proceeding stands dropped.
Item 11, my personal appearance will be dispensed.
Personal appearance. What is the order you are challenging? Sorry, which order has been violated?
Item 10, my lord.
Huh?
Item 10,
Item 10.
7 to 22, my lord.
This order you are alleging disobedience. This order has been violated.
No, my lord, read petition order.
The writ petition WPC number 3755 of 2022.
My lord.
And the order is dated 7/2/2022.
22, my lord.
That has been stayed.
In the writ appeal has been stayed.
These matters regarding that job contract.
Counting your entire case.
Item number 11, my lord. Order dated. Your lordship order dated 24/7/2023 has not been complied. Your lordship, your answer warrant. I am permitted to read the operative para 8, page 6, madam. Considering the submission made by the Honorable Counsel appearing for the parties on a careful examination of the background facts of the present case, the court deems it proper to dispose of the petition with a direction to the Director of Health and Family Welfare
But
Department.
this is contempt matter. Where is the writ? Where is the writ order?
Madam, page 7, I am reading now, page 7, madam. Opposite party to sanction and disburse the financial benefits as is due and admissible to the petitioner by taking refixing of pay of the petitioner pursuant to letter of Chief District Medical and Public Health Officer, protected
Yes,
16/7/2022 under Annex 4.
Yes, Your Lordship, we have complied with the order, Your Lordship. We've also filed a compliance affidavit, Your Lordship. The pay has been refixed, Your Lordship. All areas of pay and pension benefits have been already dispersed, drawn and dispersed to Mr. Mahanti. And his pension book and papers have already been sent to the Accountant General.
Nothing has been communicated to the petitioner. So how the petitioner know?
communicate.
So Lordship will communicate, Your Lordship. I'm serving a compliance affidavit, copy, Your Lordship. The order is. Yes, Your Lordship.
Letter compliance affidavit. Compliance affidavit, you are ready to file.
We've already filed, Your Lordship.
You have filed.
Yes, Your Lordship. The and
But that can be
is
filed.
compliance. Copy, Your Lordship. Yes, Your Lordship.
Compliance affidavit is said to have been filed. Online, come on behalf of contemners. So, let a copy of the said affidavit be served on learned counsel for the petitioner. Let's this matter on next Friday.
Item 12.
You'll also kindly see page 18, the order of this honorable court. The judgment of this honorable court, Minister 1, page 18, ma'am. You got my lord? 18. Judgment. 19, the last one.
Yes,
Read my lord. In pursuing this order, my lord, then issued a daily wage basis order. And this honorable court earlier said that without prejudicing rights and claim, then this honorable court will contempt of the last day 21/5 directed the petitioners to join their respective post of temporary appointment of daily wage basis without prejudicing the rights and claims of the judgment. My lord. Then they are also directed to comply the order fully. Then this court on 21/6 adjourned to this to comply. Because my submission that petitioners were retained in 2001, 1240 of the junior are retained in the service. So they have gone to the tribunal. Tribunal directed them to make them appointments on the available vacancies because juniors are regularized. They have not complied. In contempt application, they say out of 43, only 14% are eligible to be appointed by them. Contempt was dropped. As because that 14 also not given appointment, we filed this writ application. Saying that in contempt, once they have said that the 14% are eligible to be appointed, they should give us appointment. This judgment was passed. In the judgment, this court, therefore, this court has an agitation.
My lord, so far as the claim of the petitioners, there are two contempt acts. Without prejudice to his claim, they have already been given, re-engaged in the post, with the monthly wages of rupees 11,000.
Daily wage, my lord, not monthly. Sorry,
My lord, so far as the regularization is concerned, the government is filing rate appeal against that order, but they will continue in this for will be still any order is also.
no, but when was the order passed?
This was in recently they have joined this month.
order was passed on 22/8/2023.
File your so-called affidavit, we will consider, the court may reject that.
Yes, we will file.
Because on the basis that you are contemplating to file a writ appeal,
We will file it so far, next time.
week's time allowed for the state, for the contemners to file
Giving all these for
so-called reply.
Item 13.
and 2 weeks.
9 weeks.
Madam, the order of the Annex 2, both are similar, madam. 12 will both words.
Item 13.
Madam, please, madam. The order at Annex page 12, my lord. Operative part is page 16 So page 16 paragraph 10, my lord, kindly see. Page 16 paragraph 10. My lord, directed to calculate and release the pension benefits which 18 interest thereon. I return it on the 18, my lord.
Yes.
However, I have received the instruction. Your Lordship may kindly have a glance. Page 3. The specific instruction has been issued to the agriculture district officer, district agriculture officer to implement the order. And in the meantime, the unutilized leave salary of the petitioner has been released. And so far as his final pension is concerned, my lord, they have already moved the for vigilance clearance, and it will be done within a period of 3 weeks.
File your SOCOS.
We'll file this over.
Director after person because order not complete. I return the 18. 6 years passed in the meantime. I have returned from 18, my lord. If applicant no, 18 retired. I have retired. 6 years passed in the meantime. And option 21 already passed. 23. Will they not come from director and director personal secretary? Till then that only they are released in some leave salary that is without any interest to me.
No,
Kindly consider my lord. Entire person. I think second contempt. After disposal, again second contempt. And they have now said that the director, therefore, a director, we have a personal secretary, why are not complying?
we are complying with the order. My lord, we have already sent for vigilance clearance because that is a requirement prior to sanction of pension. That is the last page of the instruction, if your lordship will find. Will comply the order in full within a period of 3 weeks, my lord. 3 weeks time may be granted, it will be complied in full, my lord. The last page of the instruction, your lordship may kindly see.
My lord, kindly order of
They have only sought for the vigilance compliance.
4, director personal, 26, 4, my director personal, he is not complied. Including also 3 months passed, more than 2 months passed, nothing has been done.
The last one. So you will not be required to file third contempt.
This is not my lords. But they are not, but pension case also can consider.
It is.
It will be done in 3 weeks.
And interest on tax also they will get.
Sale of arms indulgence. 3 weeks time is allowed for the contemners to file a so-called reply as to why contempt proceeding be not initiated against them and they be not punished for deliberate disobedience of this court's order. 3 weeks.
Again, yours. Fine. 50 minutes after 3 not taken up.
Old matter item number 15.
Fine.
14 original. Members.
No one appears.
Item 15.
No one appears. Dismissed from the court.
Item number 16.
I'm sorry, my lord, that item 13, there was a direction for personal appearance. So it may be dispensed for the time being, and it will be.
It's dispensed with. If in the meanwhile, a court's order is complied with.
Item number 16.
Dismissed.
Item 17.
Dismissed.
18, 19 already written. Item number 20.
Dismissed.
Your Lordship, item number 20, I am on VC.
Yes, please.
The petitioner, yes, the petitioner files this contempt petition, which arises from contempt petition number 930 of 2016, which was disposed of on 13/1/2017. Your Lordship may kind of a glance at annexure 3. That is at say,
Which is the main order?
Yes, Your Lordship, the order is at annexure 2, page 16.
That has, there is nothing in that order. Where is the order? Which order was required to be complied with?
Yes, Your Lordship, this content petition number 930 of 2016.
Mr.
Page
Sir,
18.
the order passed in the writ jurisdiction, in writ petition.
Yes, I have, no, Your Lordship, I have annexed this to the content petition number, this present contempt petition at page 18. Your Lordship may kindly have a glance. Third, counsel for the petitioner, it is stated that the order dated 27th of 27/11/2015 passed by this court in writ petition number 4882 of 2004 has not yet been complied with. Let the authority comply with the same. If not complied within the meantime, within a period of 3 months from the date of communication of this order, contempt proceeding is accordingly disposed of. Requisites for communication of this order shall be filed within a week and the further. And thereafter, actually, they have complied partially. They have paid, they were supposed to pay 1,02,000 and odd.
Who has disobeyed?
Pardon, Your Lordship?
Who has disobeyed the order?
They are the contemptor number 1, Sunil Chandra Mahanti. Then second is Govind Chandra Vishwal.
All right, notices go to them.
The notice is not sufficient against them because I cannot appear for them.
Notice was
Yes.
already issued to them, but they
The notice says in the list that notices are not sufficient. So he
Take steps for service of notice.
again.
Take steps for service of notice. For a service of notice with correct and present address.
Item 21.
Visits 2 weeks. 8 weeks. Yes.
Item 21. Item note 22.
May I please, Your Lordship? My lord, the order was passed on, my lord, 31/3/2016, my lord.
Where is that?
My lord, that I have quoted, my lord, here is the order. Copy of the order, I have quoted that in paragraph 3, I have supplied a copy of the order also.
Yes, what was the matter about?
My lord, this was the matter, my lord, in my lord, your lordship, that Konark, my lord, the temple, near Konark temple, you had a shop, my lord, the unpaid parlor granted by the government. My lord, after the renovation work taken over by the ASI with the my lord, collaboration with the government of Odisha, they wanted to create my lord, zone of different zone for this my lord, shop holders. So they wanted to evict me. I approached this honorable court. The court said that since they are already having another slot, you allot him one and then evict. And till then, status quo will be maintained, my lord. In the meantime, they have, my lord, demolished. Neither they have, my lord, they have demolished my shop.
Who has demolished?
My lord, the NSC, Konark NSC, my lord. Konark NSC, my lord.
NSC, what is NSC?
My lord,
Notified area.
notified area council, my lord. They have filed an affidavit. My lord, I have also filed a counter to that. They have filed an affidavit that we have not demolished, we have only shifted. I have the photograph to show that we have demolished, already demolished. I am nowhere now. Neither they have revisited me, neither I was allowed to continue.
What reply to my affidavit was filed, I do not know because you have not served. I know whether.
Yes, I have served the copy.
It has been shifted. Now for this road, now his shop was in front of the Konark temple. So the Indian Oil Corporation was given that particular area for development. And it has been given to that. And archaeological survey is also a part of there. Now, my lord, he has been given as permitted to run a unpaid shop there in front of that. And when the development work was in progress, he has been asked to shift that. And that was also the agreement that when the NSC will ask within 24 hours, you have to vacate. And it is not that they have demolished. They have, he himself has shifted that. And that too, he has been asked to do this shop in backside of that area. It is not that they have never demolished, which is my affidavit also.
This is totally false statement, but I have given the photograph, they have demolished. I will give you this photograph. Date is there also, 10/8/2022, they have demolished.
22.
22.
22, but the
They have filed the count, they have filed the so-called application 2017, but thereafter they have demolished.
I don't find that the contemplative application has been filed in 2017. Now my learned friend is saying that it has been demolished in the 2022.
They did not comply with the order till now, neither they have allotted.
This is what he is saying,
Yes, madam.
that you filed the contempt application in 2017.
Madam.
And you are relying on this photograph to say that it was demolished in 2022.
That is,
22 is different.
but the order has not been complied yet, madam. The order was, madam, you lost in the CBA, what was the order?
Yes, I have seen the order.
The till that date, unless I have allotted a stop, I'll be allowed to continue there. Had they allowed me to shifting to a different place, I had no problem, my lord. Initially, they shifted to 5 meters. Thereafter, they demolished.
They shifted.
Initially they shifted me for 5 meters, around 5 meters. Thereafter, they have demolished. Now, without applying, without giving me a stop.
It is a different cause of action.
Yes.
See, if it was done as per the order, you are saying necessary direction to opposite party number 3 to identify unfair outlet
Malo.
within Konark NSC
Malo.
within a period of 4 weeks.
Malo.
That was done.
Malo. No.
You are saying within 5 meters something was given to.
No, that my shop was, Malad, I was asked, I shifted myself. Thereafter, they are supposed to allot me a shop, Malad. That they did not do, Malad.
Yes, where the shop was allotted.
No shop was allotted. In the new place where the cluster of shops has been rebuilt, cluster of shops, there was supposed to be a provision for unpaid parlor. That is not there.
But where is the direction for allotment?
No direction to the Konark NSC in fact. Yeah, my lord. But there was an agreement and there is an agreement so that.
Where is the direction for allotment?
Now, the direction was, in view of the discussion made over, the court disposed of reiterating the direction of the opposite party for Collector Puri to issue necessary direction to the opposite party of 3,000 go to identify an unpaid outlet within Konark NSC within a period of 4 weeks from the date of production of the certified copy of the order. In such event, the petitioner will shift their shop unpaid parlor till that the status quo will maintain.
To identify and see, this is
they just would say that we are in this place they will be constructing, so you just move away.
All right.
They are not identified in the unpaid parlor for me, my lord. They are supposed to, unpaid parlor is a government scheme shop, my lord. I was allotted under the government scheme, my lord, to cater the need of the traveling tourist, my lord. That has not been done. They are not allotted, they are not find out any.
The court is required to go by the nature of order passed.
My lord.
It is not that identify means if they identify some place that you can go there. You can go there. The place was identified, you were shifted. According to you were removed in 2022.
Yes.
So till this was done, you did not have any grievance. So now after 2022, you have grievance. So that order cannot be in 2017. In any case, no disobedience was made out. You filed it in 2017.
You are losing that.
Subsequent.
The losses that in fact I had filed another writ application challenging that demolition.
The following was.
But actually, I'm giving that number.
Just a minute. Passed by this court on 21/3/2016 in WPC number. What is the WPC number?
30207 of 2022.
No, the earlier.
Earlier is my lord, 21370 of 2014.
21370 of 2014. No, sir. Order manager petition or High Court. Stop. The counsel appearing on behalf of the petitioner has submitted that in disobedience of this court's order, the petitioner's outlet has been demolished recently in 2022.
10th of August 22, man.
Stop. This contempt application was filed in 2017. Stop. The petitioner's outlet was shifted from its original place to a place nearly
5 meters away, man.
5 meters away, according to land counsel for the petitioner. Stop. In the court's opinion, on the date of filing of the present contempt application, no deliberate disobedience of this court's order is made out. Stop. And counsel for the petitioner has submitted that against the action of demolition, a writ petition has been filed, giving rise to
The WPC number 30207. 30207 of 2022.
22. So the contempt proceeding is accordingly dropped. So it is made clear that the petitioner shall be at liberty to pursue his matter in WPC number so and so,
30207 of 2020.
as I have not expressed any opinion on the legality or otherwise of the action taken by the monarch NSE in removal of the petitioner's outlet.
Item 23.
None appears.
Order has been complied, we have filed the complaints.
Compliance affidavit has been filed on appeals on behalf of the petitioner. Compliance affidavit has been filed on behalf of the contemners to the effect that this court's order has been complied with. The contempt application, the contempt proceeding stands dropped.
Item 24.
First,
Item 25.
In the President contempt petition, my lords, your at page 14, my lord, the operative portion of the order passed in WPC number 13/384 of 2016. My lord, we have filed the compliance affidavit. I don't know whether it is on record.
I'll have a glance.
ପାଇଛନ୍ତି ଆପଣ?
Na kichhi to paini.
No, I am giving a copy to because on 4th July we have filed it. Right now I am serving it and your lordship may fix it.
counsel for the contemner states
Without it,
the AG appearing on behalf of the contemner states that compliance affidavit has been filed.
Yes, on 4th July 20.
I have not, sir.
Has been filed on 4th of
I
July.
have not, sir.
So this said affidavit is not there on record. So let a copy of the compliance affidavit be served on land counsel for the petitioner by Monday. Let us keep it on Friday. Next Friday.
Item 26. Sorry, 26. We'll run back. Item 27.
No instruction.
Item 28.
28, my lord. The operative person of the writ petitions ordering my contempt application, my lord. Just at a glance, I have quoted in the
Where is the order?
order I have quoted in my contempt application, my lord. I am just reading. Her, it is submitted that the petitioner's husband died in harness. It is further submitted that if he would have continued in service, he would have retired after the 1986 rules came into force. As such, he would have been eligible to receive pension. This question has been answered by the court in the case of Suvarna Divya and others connected matters. OJC number 3891 of 2000 disposed upon 10/5/2004. Accordingly, this writ application is disposed of, giving opportunity to the petitioner to file suitable application before the concerned authority, who shall consider the same in the light of the ratio of the decision referred to above. Thereafter, the old lady has approached opposite party number 3, and the opposite party number 3 by annexure 1 of the contempt application has said that the matter has been approached in the Supreme Court of India in Suvarna Vidya and others. Subsequently, in 2015, that matter has been dismissed. Thereafter, since 2015, up to 2 years, the authorities have not done anything. Now, in the guise of a notification, they have come in the so-called affidavit that I am not entitled to. Because
We will have to challenge. There is nothing, no observation at all.
I am a 75 years old lady, sir. Because of there, I am filing the contempt. I have just a glance to the contempt application.
Please read the order. And please read the order, and with reference to the order, tell the court that this part has not been complied with.
Yes,
Read the
sir.
order.
That this question, according to this writ application is disposed of, giving opportunity to the
So that
petitioner.
was opportunity to you,
Yes,
to the petitioner.
yes, my lord. I am entitled to, because similar footings last
Which direction has been disobeyed? Read the order and tell the court.
my lord, this since 2000, this is the order, my lord, it is in 2005.
Please answer to the court's query.
Yes, my lord.
Which part of the order has been disobeyed?
Because
You will have to show that this is the direction which has not been.
after this writ petitions order, I approached the authority, my lord, and the authority just have a glance under annexure 1, my lord, that they have referred the matter to the without they referred the matter to the Supreme Court, and the Supreme Court it is the dismissed in 2015, and thereafter 2015 again I approached in 2016. What we have done? They have since 2015 nothing has been done. In my application is under annexure 2, it is 27/2016 I have approached. Then they have done nothing. And thereafter I have filed my contempt application 17.
What was the direction? I was,
Direction, because I am entitled,
you may be entitled, but
entitled under the Suvarna Vidya case, because several cases, several people have received, because I am died while serving, harness I died, my husband died. I am in seven, after more than 70 years, I have
difficult. What is your stand?
My lord, your lordship may see, pursuant to the direction of the honorable court, the block education officer has passed an exhaustive order after dismissal of the Supreme Court's order.
Where is that?
That is at annexure B/3. Office order number 82 dated 21/1/2019.
Annexure
Referring
B.
the order of this honorable court. So if he is aggrieved by this
No,
order.
where is that annexure?
That is so cause annexure B/3 at page 18. So cause filed by the BEO Harbanga.
BEO, no? So call.
so-called
Filed by BEO, the Harbanga. All right.
my lord, may I submit? No?
Yes.
My lord, under annexure C/3, a notification or dated 28th May 2017 has been annexed.
Sir, please.
In the second page,
See, in contempt jurisdiction, I cannot go into such discussion.
I bow down my lord in this contempt application I have to, because your lordship read court also. I am 75 years old.
Not,
Lord, your lordship will direct that this is under.
not do, that will be an illegal order.
Right.
If I issue any direction.
I right, Lord, that is right, but I am submitting this lady is the judge.
Lady, see, this order was passed in 2019.
2019, since 2015, Suvarna Vidya dismissed.
You could have challenged this order.
No, I don't have any, the authorities did not do anything since I approached the authority in 2016.
No,
There's nothing about it. I told lady, I approached in 2016.
if she is a poor lady, then ask her to.
No, see, the guy is
Unless discussion between you and me.
No.
Continue.
No, just have a glance to under annexure CI3. Just have a glance, Miller. In second page, Miller. I died in 2074 and
You are alive.
my husband died, Miller, my husband. Sorry, Miller.
If there is any error in
In the Odisha, just a minute, in the Odisha aided educational institution, non-government fully aided, they have transformed the rules, or amended the rules by notification. And saying that the opposite party number 2 is saying this is a public on policy decision. I am a poor lady, just have a paragraph, then your lordship.
You are a poor lady and I am a poor judge.
No, lordship.
For the reason, no, for the reason. Not,
Where go?
no, not, that is not the reason.
I bow down, just have a glance to
Not that
that.
I am a poor judge means something else. It means that I have my jurisdiction is limited.
Right, my lord.
So my jurisdiction.
My lord. In the Odisha educational institution, non-government aided primary school teachers retirement.
To Mr. Counsel, in fact, you should have challenged this order. And if you can't challenge the order, I can ask the legal services authority to pick up your case.
I will challenge.
The
But my lord, but still, my lord, I am, my lord, since 2015, Suvarna Vidya's case, they have done nothing for 3 years, my lord. Because and thereafter they started this notification. I am not this notification.
Do you know the client is suffering because of you also?
They have given
Your client is suffering because of you also.
because in so-called notification they filed this.
Do you understand this observation of the court that your client has suffered because of you also?
Sure.
The order was passed in 2019. You are pursuing your condemned matter in 2024 without challenging that order.
This was last year 21. This 10 to 2021 I argued, my lord. But subsequently the matter has been due to COVID. The matter has been not.
19 the order was passed.
No, they have filed the so-called notice. They have filed.
All right. The petitioner has alleged disobedience of this court's order dated 14/5/2004. What is that order? Order was passed in 14/5/2004.
My lord.
And you filed this contempt application in 2017.
17, my lord. This matter was referred to Supreme Court and it was dismissed in 2015. I approached the authorities in 16. Thereafter, I filed the contempt.
So you did not approach the authorities as directed by this court. Disobedience of an order of this court dated 10/5/2000. Dated 14/5/2004, passed in WPC number 5041 of 2002, operative portion of which reads thus. Paragraph 1 second. The present contempt application came to be filed in 2017. So stop. When did you file your representation?
Representation in 28/7/2016.
Very good. In compliance of the said order of this court dated 14/5/2004, the petitioner is said to have filed a representation in 2016. So stop. Next, it is worthwhile noticing that the decision in case of Suvarna, Divya and other bracketed Supra was under challenge, and finally the SLP came to be dismissed in 2015. So stop.
19 to 15.
Huh?
19 to 15.
On 19/2/2015. So stop. On the petitioner's representation, an order has been passed, which has been passed by the block education officer Harbanga on 21/1/2019, which has been brought on record by way of Annexure B by 3 to the so-called affidavit filed on behalf of opposite party number 3. Stop. Next, learned counsel appearing on behalf of the petitioner has vehemently submitted that rejection of the petitioner's claim by the block education officer is not justified. Stop. In the present contempt proceeding, in the facts and circumstances noted above, as the petitioner herself filed a representation nearly 13 years after the order was passed by this court, 2004, section 12 years ago. I am not inclined to proceed in the present contempt matter. Contempt proceeding stands stopped. The petitioner shall be at liberty to question the correctness of the order dated 21/1/2019 passed by the block education officer.
Item 29.
Item 29, Lordship, this is the second contempt matter. Here the Tahsildar was directed to dispose of the Bebandobast case, but still he hasn't
Where
complied.
is the order?
My lord, if your lordship may kindly peruse page number 2 of the contempt application, the court order has been quoted in there. The order is also there in annexure page, annexure 1, page 7.
Yes.
My lord, if the instruction is available in my office with this record that pursuant to this honorable court's order, hearing was conducted on 6/5/2016, and as per the field inquiry and hearing status of the case was finalized by the Tahsildar on 10th March 2017 and sent to Sub-Collector Sadar Sundargarh on 22/3/2017 for confirmation, because Tahsildar has been directed. He is not the confirming authority. He has to send the file to and afterwards, the Bebandobast case was returned to the Tahsildar for compliance on certain grounds. After due compliance, the case record has again submitted by letter number so-and-so dated 16/4/2018 for confirmation. Further, the Sub-Collector Sadar Sundargarh for return the file so-and-so on certain discrepancy. Recently, after report of compliance is submitting to the Sub-Collector Sadar Sundargarh by letter so-and-so for confirmation that a time petition was filed before the Honorable High Court on it. So, it is in the process, and the Sub-Collector has made some query, and the Tahsildar at his level he has disposed of. But he can pursue the matter.
On the part of Tahsildar.
He can pursue the matter, right?
Part of Tahsildar, there is no disobedience.
No.
And the direction was to the Tahsildar.
So he had to comply with the same.
File your reply.
Yes. 2 weeks time.
2 weeks.
Most of it.
Item 31,
Not present.
Not pressed.
item 32,
No, no.
No.
So it's for yeah, just with a request to pass over, my lord.
Let it be taken up next Friday.
Next Friday.
Next Friday. As requested.
item 33,
Not placed, ma'am.
Not pressed.
item 34,
34 is disposed, not,
No, ma'am.
somebody has.
I am for the petitioner of non-compliance of order dated 14/1/2016. The relevant portion of the order has at page 9, my lord. The last portion order has not been yet complied. The interest part of the order has not been complied.
Yes.
The letter I have received recently that the entire benefit which he is entitled to get, the elementary education director.
But what about the interest part?
That we have, the instruction is that they have forwarded it to the controller of,
I received the monetary benefit.
control of accounts for confirmation. It will take
3 weeks.
3 weeks. Obliged.
35, no compliance has been filed well listed. No.
Compliance. Compliant.
They will file.
They will file, but you also must be knowing whether it has been complied with or not.
Not complied one.
Where is the order?
No, 35.
If I,
Lord, perhaps it is listed for the first time, my record.
65 year,
Yes, 35, 1099 of 2017.
so it has been. You cannot take this plea.
Lord,
Okay.
yes, that is, but no your lordship may kindly give
36.
36. It is 35. This is 35. कौन कौन है कि चाहिए डेवलपमेंट के जान से
Dismissed.
Item 36,
35 adjourned.
Dismissed.
Order of this online report dated 19/1/2015 and thereafter order dated 20th/7/2016 not complied.
Where is the order?
First, the order is at page number 8. The first order is at page 6. Order dated 27/10/2016. Previously, the main order was dated 19/1/2015. There was a direction to the.
Where is that direction?
Let-
Where is that direction?
I have put it at page 2, paragraph number 2 of the contempt petition.
Paragraph number 2.
2, yes, sub-paragraph. Consider limited nature of the offense of the petitioner that the matter related to death can return from gratuity. It is pending since a long period. This court dispose of the petition with the direction to opposite partner to dispose of the dispute pending before him.
Yes.
At 2 weeks time because there is no instruction.
Also, no instruction. Why no instruction? Your officers don't know.
My lord, meanwhile, they have also amended the contempt petition. So
No, not amended. Here, since that order was not complied, we filed one contempt petition. Saying see paragraph number 4. In that high order dated 27/10, the honorable court granted them 1 month more time, 3 months more time to comply with. In
No,
spite
that is different.
in spite
But
of,
why your officers are they, do they have this audacity not to inform their lawyers what is, I am taking up the 2017, 2016 matters and they are not giving instructions.
might have been complied or having. He
what
also
happened after this
just,
second,
just one adjournment. I will
2017 an order was passed, even before that, 2015.
minute after the first contempt,
2015 an order was passed. Why first contempt, second contempt?
this should have been complied forthwith, but whether it is complied, only 1 week time may be granted. Next Friday, I will get the instructions.
The court expresses displeasure over the circumstance that learned AGA does not have any instruction in the present contempt matter as to whether this court's order dated 19/1/2015 passed in WPC number
25689 of 2014.
has been complied with or not. Full stop. This is despite the fact that these cases are being listed after due notice and opportunity to the contemners to inform this court regarding disobedience of, regarding non-compliance of this court's order. Full stop. List this case on Friday. Stop. The court will take strict view of the matter in this case and in other similar cases also, raising issues of disobedience of this court's order if the contemners fail to supply necessary information to the Office of the Advocate General or the concerned AGA as regards compliance or otherwise of such orders.
Yeah, pardon, my lord, item 65, my lord, not a plate now.
65.
65, not.
86 also, Major. Double six.
60.
But we are giving compliance. Wherever the order has been complied or we are giving.
Give.
Coach in what देखने के लिए को item 172.
172.
My lord, item 40.
item number 74 and 163. I may permit to withdraw.
64 and
74 and
74, 163.
My lord, I need coordinate.
Item number 37.
My lord, I need coordinate 41. I want to file a short petition because the petitioner is a tired man.
38. So, brief has been taken away by the petitioner. And order is there.
order has been complied with.
Brief has been taken away.
Then counsel for the petitioner states that the petitioner has taken back the brief and he does not have any instructions to press this application. Contempt application. Contempt application stands dropped accordingly.
Item number 40.
40.
39. Withdrawn.
The non-compliance of the order dated 7/9/2016. And again, there is order passed on 4/9/2019.
Yes, where is the order?
The order is dated 7th September 2016. 792, that is the contempt petition, page.
What is your instruction?
My lord, we have filed this so cause exhaustive. Let me place before your lordship what has happened. The order which is sought to be implemented or subject matter of the contempt petition is reads as thus. Since the order is passed at the admission stage, petitioner is directed to, yes, I'm sorry. State counsel, there might be an appeal against the order under this writ petition stand disposed of with a direction to the concerned authority that in the event there is no legal impediment in implementing the order under Annexure 1, the same shall be given effect to within a period of 4 months. This is the order. The order sought to be implemented is an eviction order. What has happened that thereafter, that is why since the order was passed on the first date, the Honorable Court has observed that if there is no legal impediment, the same can be implemented by the state authority. But thereafter, that order was challenged in appeal. Then again in Honorable High Court, that second order of the Honorable High Court that I have annexed in my so-called affidavit, your lordship may see my so-called affidavit at page 32, annexure G/2. This writ petition is subsequent to the writ petition in which the order was passed, which is sought to be implemented.
Yes. No,
My lord. Page 6 counter. They have stated the eviction notice issued fixing for eviction 7/1/2019, but till date no action has taken.
Who had encroached?
The opposite party.
He was noticed.
No, he has not been.
The petitioner has alleged disobedience of this court's order dated 7/9/2016. Passed in WPC number 14078 of 2016. The said writ petition was filed for implementation of an order passed by the collector Kendrapada on 8/8/2013 for eviction of unauthorized encroachers. So, the writ petition was disposed of with a direction to the concerned authority that in the event there was no legal impediment in implementing the order, said order, shall be given effect to within a period of 4 months from the date of communication of the order. Stop. The writ petition was disposed of on the same day when it was taken up. Stop. The encroachers were mid-party.
My lord.
Encroachers were parties in the writ petition.
I am the petitioner, my lord.
Oh, writ petition.
I am the petitioner.
No, encroacher opposite party. Writ petition, whether encroacher was a party.
Encroacher was a party.
But it was on the first date it was disposed.
The persons who had allegedly encroached upon the land were parties in the writ proceeding, but were not noticed before passing of the order. Stop. What happened there after in appeal? What happened?
Appeal was dismissed. Appeal was before and appeal was dismissed. Then he carried the matter to the Honorable High Court. Honorable High Court gave them liberty to file revision. Then he filed revision. And this is how the matter is going on. And that order has already been superseded by the order of the Honorable High Court in subsequent order. That is.
Again, there is order in contempt petition, my lord. 4/9/2019.
In the
second contempt, out achi.
Yes, contempt it has 19 order is
1/9/2013 passed by the collector was subject matter of challenge in an appeal and subsequently
1/9/2017
the matter
Appeal number 23 of 2017.
appeal being appeal number 23 of 2017 before divisional commissioner.
Before the sub-collector Kendrapada.
Collector's order cannot be collector.
Tahsildar's order, appeal is sub-collector. Tahsildar order.
Collector is Tahsildar.
No, Tahsildar is the lowest authority, then sub-collector is the appellate authority.
Now, in the order, it is mentioned passed by collector Kendrapada.
And that is,
7/9/2016 order. Annexure 1.
that is the order of the Tahsildar actually. He preferred the appeal. He himself preferred the appeal before the sub-collector, the encroacher. Encroacher. That was dismissed, then he carried the matter to the High Court in WPC 2095 of 2009.
Was subject matter of
Challenge.
appeal filed by the encroachers, registered as appeal number 27.
23 of 2017.
23 of 2017. So, in any view of the matter, considering the nature of the order passed by this court, and in the circumstance that no disobedience of this court's order is made out, the contempt proceeding is accordingly dropped. No willful disobedience. Yes.
Item 41. None.
First.
Item 42.
Yes, Mr.
Item 43.
Sorry, 43 already complied in that.
Complied with.
My lord, item 41, your lordship dismiss, my lord.
40.
41, my lord.
Ah,
My lord, in this case, petition has a died, my lord.
right.
So I will file the substitution petition, my lord.
Why substitution? Contempt, where is the question of substitution? 40.
This one. 41.
41, my lord, 41.
What will you do in contempt matters by
And I
substitution?
will file the substitution petition because of this petition has a died on
My lord, what has happened in this case, the petition
20 June 2021 died, my lord. So I will file the petition for substitution, then your lordship had, my lord.
Let me see where is the order first.
the petition was filed seeking a direction to the revenue inspector to collect the rent from the petitioner. And the honorable court directed that to consider. That was not accepted, for which we have also filed the show cause as to why we could not accept the rent. Now, if the legal heirs, they can again approve because that order is no more there after the death. So
No, my lord, my lord.
the legal heirs.
My lord, I may be permit, my lord. Now, I tell my husband, the land was recorded in my husband's name. I am the wife.
So you can
Then
challenge,
after,
you can challenge the decision. There is no order which has been violated.
my lord, yes, my lord,
Challenge.
violated by the Tahsildar because I have filed the application for mutation after death of my husband.
Let me see the order, then speak.
Yes, my lord. Your lordship may can order of declare 28/6/2017, my lord.
Where is that? Where is the order of this court?
Page 6 of the contempt petition.
Your lordship may kindly take up some other date.
Page 6. The opposite partner 4 is directed to accept the land revenue from the petitioner as and when tendered, if there is no other legal impediment.
Yes, that was the order.
And in the so cause, I have explained what are the legal impediments for which I could not,
The
Mala, I requested my friend to serve a so cause notice because a so cause notice is not with me, my lord.
served upon him, serve upon him. As it is stated by learned counsel for the petitioner that the so-called affidavit filed on behalf of the contemners has not been served upon him. This case on next Friday.
Yes, my lord. Yes, my lord.
Need a copy of the so-called affidavit be served upon him in the meanwhile.
Oblige, my lord. Oblige, my lord.
Item number 44.
May I please, Lord, sir? You know, the order coming from the ground crossing that, you also may kindly come to page 12. Page 12, Lord, sir.
Yes.
Order dated 28/1/2013, Mula. Considering the limited nature of grievance raised on behalf of the petition, it petition disposed of directing Tahsildar Kokosara to take appropriate action in accordance with law in the light of order passed in the OLR revision case of 9/2001 by the law member Board of Revenue. That has not been implemented, that has not been implemented by the Tahsildar.
And the order has been passed, which is available at annexure C/2 of my so cause. That is already complied, but he is saying that is not in accordance with the, because there was no specific direction. Somehow the order has been passed by the concerned Tahsildar, and if he is agreed, he can challenge it in proper court of law.
Challenge that. The in compliance of this court's order dated 28/1/2013, passed in WPC number 30857 of 2011. The 11, violation of which has been alleged in the present contempt application, Tahsildar is said to have passed an order. In the light of the order passed in OLR revision case number 9 of 2001. Stop. In such view of the matter, no case of willful disobedience of this court's order is made out. The petitioner shall, however, be at liberty to question the correctness of the order which has been passed in compliance of the said order of this court dated 28/1/2013.
Item 45.
Dear my lord, order dated 23/3/2017 has not been complied. Nothing is there, my lord. So cause has been filed, but no copy.
So cause has been filed that we have complied it, and inquiry was conducted as per the direction, and collector has passed the order. That is annexure.
But copy should maybe third one.
Give him copy.
Yes.
Is this case on Friday? So as to enable London State Council to serve a copy of the compliance affidavit on London Council appearing on behalf of the petitioner. Yes,
Well, item 46.
Thank you. The non-compliance of an order dated 12/5/17 passed in the WBC number by which this honorable court was pleased to direct the present opposite to take the decision on the representation of the petitioner within a period of 3 months from the date of receipt of the representation and communicate the decision to the petitioner.
yes,
Yes, my lord, so cause affidavit has been filed. The
serve a copy.
no, and the copy there. Actually, copy has already been solved.
Then it has been complied with,
It
madam.
has been complied. But yes,
Complied.
No communication.
communication, communicated. Copy दिया है ना, दिया है.
So cause copy, কিন্তু complied copy दिया है.
In so that has been complied rightly. He has filed a rejoinder also that has been complied, but only thing is that she is saying that I am entitled for more benefit. That she can challenge it. Yes, you can challenge.
Considering the so-called affidavit on behalf of the contemners in the court's opinion, the court's order dated 12/5/2017 passed in WPC number 8403 of 2017 has been complied with, in as much as the petitioners' representation has been considered and a decision has been taken thereon. So, and counsel for the petitioner has submitted that the petitioner is entitled to more benefits than what has been granted by the contemners. So, in view of such submission, this contempt proceeding is dropped with a liberty to the petitioner to take a recourse to appropriate provision of law if he is entitled to more benefits than what has been granted to him.
Item 48.
Non-compliance of order dated 21st June 2017. Case 7 contemplation. Considering the rival contention of the parties and taking into the consideration the pleadings and the observation of this court in the decision of Ritanjali Giri Supra, the writ petition stand dispose of the with direction the opposite party authority to extend the benefit of a rehabilitation appointment to the petitioner following the direction contained in the decision of Ritanjali Giri. The entire exercise will be completed within a period of 1.5 months.
My lord, in this case, pursuant to the direction of the honorable court, the director against whom the direction was issued, he has already submitted the necessary records to the district education officer, and I have to take the instruction what is the current status. Lords may grant me 2 weeks time. The letter by which this matter was referred to the DO, that has been annexed as Annexure A by 1 and B by 1. I have to take instruction about the current status. That so cause is there, already there on behalf of the director.
2 weeks' time is allowed by way of last indulgence to the contemners to inform this court regarding full compliance of this court's order, violation of which has been alleged in the present contempt application.
49.
Dismissed.
Item 50.
May I please, your lordship. My lord, in this case, I have non-compliance of order dated 5/10/2016, your lordship. The orders were that to take necessary steps and initiate proceeding pending under the OPLE Act. Lordship, the petition,
Where is the order?
the order has not been annexed. I beg your pardon. The writ petition is there, has come up, lordship, along with it.
Order annexure hai neither it is quoted nor annexed.
No, it is annexed with the representation.
Lordship. No succos has been filed by the opposite parties.
There is no direction.
The direction was that
No direction at all.
if any proceedings
No. With a direction to opposite party number 2 to look into the grievance of the petitioners.
lordship,
And if required,
lordship,
so required, so he might have felt that it is not required. We don't know. Following is the order passed by this court dated 5/10/2016 in WPC number 13190 of 2016, violation of which has been alleged in the present contempt application. Stop. There was, it is apparent from the said order that there was that the prayer that this court did not issue any positive direction to initiate an encroachment proceeding. So stop. the court simply observed that if was it party number 3 to the writ petition found it fit, he could initiate necessary proceeding for removal of encroachment. So considering the nature of the direction issued by this court and the facts averred in the present contempt application, no case of intentional disobedience of this court's order is made out. Contempt proceeding is dropped.
Item 51.
No instructions.
52.
Yes.
No.
Huh?
One equal.
On appeal. Yes, yes.
Item 53.
I please, Your Worship. Your Worship, kindly look to order dated 17/2024 in the contempt application. Contempt order sheet. 17/2024, order number 13. On perusal of the affidavit filed by the opposite party, sorry. This court does not find any satisfactory reply. This court is of the view that regularization of service of the petitioner should have been done from the date of his joining the post as he was appointed against the sanction post by your valid selection process. Hence, the court as well as the appeals court have held that capital of decision, the regularization of service should be done from the date of joining, not from the date of judgment. The opposite party contender directed to file an affidavit in the light of the above observation on or before 28th February 2024. So this order was challenged in the appeal. This order was challenged by the contender in the writ appeal. And the writ appeal has been dismissed by the worships at factory. With that is if we look to that is a factory of the writ. The argument was advanced by Mr. Pajit that the single judge could not have gone beyond the order. So we also said that there is no required that he should move the honorable single judge. That is what that paragraph 10 also said, and the appeal was accordingly dismissed. Now, no affidavit whatsoever has been filed pursuant to the order dated 7/2024, or even no application has been filed to recall this order after the worships dismissed the writ appeal. So far the compliance is concerned, my specific cases are not complied with. I can file an affidavit also.
No, let me see the order.
Yes, sir. The judgment was passed, that is at page 21 of the book. In that view of the matter, let's get it. Page 21, para 22.
Yeah.
In that view of the matter, the court is of the considered view that the opposite parties should observe the petitioner on a regular basis against sanctioned vacant post, taking into account the length of service rendered by him as a lecturer in mathematics, in which he is continuing without insisting to undergo the rigorous selection procedure laid down under Bluetooth Act and rules framed thereunder. The reason being, in the meantime, the petitioner has become overaged and he has been exploited for more than 20 years. For no reason, though he was qualified in all interviews conducted by the authority for the engagement on contractual basis. The petitioner being not a backbone entitled to service, the opposite party university should expect all consequential benefit are due and admissible in accordance with law as expressed as possible, preferably within a period of 4 months. This judgment was challenged before the division bench. The division bench judgment is at the part A, Annexus 6. The reasoning order, that is page, that additional affidavit, page 20, the operative person, and before to interpret with the order of the honorable single judge. This was also challenged before the Supreme Court, and the Supreme Court has upheld it. That is at flag C, on the ground. So now when the contempt application was filed, in the contempt application, they initially they passed an order, but subsequently they modified that order. In the counter they have said, if you also look to that tag I, the so-called reply of paragraph 9. They say, paragraph 9, that affidavit internal case 3, paragraph 9, that the present deponent by order issued.
Where are you reading?
This compliance affidavit filed by OP number 3 at flag I. That was filed on 6/2024.
Yes.
The last affidavit at paragraph 9. Did you get it?
Yeah.
Paragraph 9. Internal page 3 of that affidavit. The present deponent.
No, I could not get that.
Myself.
Compliance affidavit filed by opposite party number 1.
No, compliance affidavit filed by OP number 3. Filed
by.
Right. Page no 112. Page number 100.
Got it.
Yes, sir. Para 9.
Renu Purva.
Yes, Renu Prabha Naik. Yes, that affidavit also come to paragraph 9. That the present deponent had ordered issued on 5/2/2024 has observed the petitioner against the vacant sanction post of assistant professor in mathematics in OETR with effect from 1/1/2015 along with the announcement bill. Just one bill. 1/12/2015. 1/12/2015 along with financial benefit. Opposite party has issued this office order in a subsequent to the letter dated 2/2024 issued by the opposite party number 2, which has been communicated to the petitioner in supersession of the earlier appointment letter dated 6/9/2020. The offer of petition is people to 1/12/2015 with all consequential benefit. The office order is also except issuing this office order, that is 5/2/2024, as they are annexed in so cause, nothing thereafter, no benefit, financial benefit or anything has been given till date. So therefore, I got some information that the state government wants to comply with the orders, even as directed by the Honorable Single Judge. That information I applied with the Right to Information Act, but the contenders, number 1 and 2, they don't want to comply with. And the only thing is that the single judge has no direction in a contempt matter, has no authority to direct with a regularization with effect on the date of joining. But the Honorable Single Judge has rightly pointed out that before the High Court she was hearing the development that writ appeal against that order, that you have every right to take all this plea, but you must file an affidavit. Though that affidavit the Honorable Single Judge are directed, they have not filed the affidavit till date. Your Lordship.
No, but see, was there any direction by the single judge that the regularization should be with effect from?
That's right. That the Honorable Single Judge has directed the opposite party university to extend all consequential benefits as due and admissible.
They will have to give.
They have passed an order, they have not given till date also. In the month of January, they said that we have done this, but till date they have not. My lordship said that we will give it, but they have not done it till now. And the affidavit, that is why the Honorable Single Judge has directed on that, of course, your lordship, the division said that is for the, you must meet the Single Judge, whatever modification or whatever it may be, but that is for the Single Judge to decide. So now they have not filed any affidavit in compliance to that order. And they have not given the benefit till now. I'll file the affidavit manner as directed. But in the meantime, Lordship may kindly peruse this order. You have passed the order.
Why should I peruse the order which are?
We have already regularized him from 2015, 1/12/2015. That's the preponed it. All that is pending is the differential financial benefits. That when it's in the process of calculation, we'll disburse it. There's no.
The process will take how long?
Whatever reasonable time your lordship grants, I'm only praying for some time. Some time.
Like.
Some month's time.
Huh?
4 weeks.
3 weeks? 3 weeks?
3 weeks.
The court is
Lordship may order recording.
prima facie satisfied that this court's order violation of which has been alleged in the present contempt application has been disobeyed. Full stop. Weight constituting contempt of court. Inasmuch as the petitioner has not been given consequential benefits. Full stop. Whether such disobedience is willful or not will be considered on the next date when the matter is taken up. Let's discuss on 3 weeks.
Can I have one, document from 1/12/2015, the benefits will be.
We
given.
don't know. I will decide on that day.
No.
Whether contempt is made out or not, I will decide on that.
No.
So if you pay consequential benefits, maybe because of such subsequent contempt, may
No,
accept
that-
your
no,
apology.
no,
Or
That was the only dispute, the date cut off. He was saying from the date that he joined as an
that
ad hoc.
aspect we will see later.
No, wait.
54. Item number 54,
No,
55,
missed.
item 56,
May I please your lordship? My lord, I am appearing on behalf of the opposite party. The order passed in WPC number 8856 of 2010 has been stayed by the Honorable Supreme Court in SLP number 8601 of 2023.
There is no representation on behalf of the petitioner and counsel representing the contemners has informed this court that this court's order, violation of which has been released in the present contempt application, has been stayed by the Supreme Court. Where is that order? By an order dated 12/5/2023, as in SLP civil number 8601 of 2023. So, and next, in such view of the matter, no case of deliberate disobedience of this court's order is made out. Contempt proceeding stands stopped.
item number 58. My lord, non-compliance of order dated 9/2/2017 at ordering postal at page 25. Honorable single judge was directed to pay all the pensionary and other benefits within 3 months. The stay order was challenged by the opposite party state in writ appeal 426 of 2017, which was dismissed on 8/12/2017. Against that order, they preferred SLP before the Honorable Apex Court. And in the meantime, Honorable Apex Court also dismissed the SLP.
When?
I have the order.
When was the appeal dismissed?
They are dismissed on 30/8/2019. And till today, they have not yet complied the.
In fact, my instruction was that SLP was filed. Thereafter, about the dismissal of the SLP, as my lord friend says, that
1
instruction.
week. If you comply, it's all right, otherwise I'll proceed.
Madam.
Is this case on? for land counsel representing the contenders to seek instructions as regards full compliance of this court's order, violation of which has been alleged in the present contempt application.
Item number 60.
Item 60, I am for the opposite party. We have already complied with the order of the honorable distinguished judge.
I am for petitioner compliant.
Complied with
61.
dismissed.
Item number 62.
Dismissed.
Item number 63.
Item 63, the petitioner alleges non-compliance of the order dated 4/10/2016. The order is at, this starts at page 7, the relevant page at page 9. The issue there was the petitioner filed the writ petition with a prayer to direct the opposite parties to grant recognition to the institution with retrospective effect from the year 1988-89 in modification of the earlier order of recognition issued by AP number 2 dated 31/3/1995 under
So
Annex
your
3.
representation has not been disposed of.
No, my lord.
Yes.
No instruction.
Who was opposite party number 1?
P number 1 is your lordship,
In the
the Commissioner cum Secretary, Higher Education Department.
and where is your representation?
My lord, that is annexed to my writ petition, your lordship. That is annexed to my writ petition.
Where is that?
Page 20 of the writ petition, Annex 6.
Is 20.
My lord, page 20 of the writ petition.
Of the writ petition.
My
A representation you must have filed after by or passing of the order.
No, lordship, if your lordship may cease, Annex 6 may be considered. Annex 6 may be considered within a period of 8 weeks. So that Annex 6 is annexed to page 20 of the writ petition.
Yes.
That's one time I'll take instruction because
One
no.
week.
No.
Yes, not, this is 2017 matter.
Yes.
1 week.
64.
Gratefully, your lordship. My lord, I want the opposite parties. Already order has been already complied. So-called have and also served on Petition Council. Your lordships can see that is annexed. So,
Counsel for the contenders is present. And the states, referring to the averment made in the so-called affidavit filed on their behalf that this court's order has been complied with. This court's order, violation of which has been raised in the present contempt application has been complied with. The contempt proceeding stands stopped accordingly.
Item number 68. Supplement. Supplement. 68.
Dismissed.
69.
Dismissed.
Item 70.
I may be pardoned, Lordship. Item 69, I'm through virtual mode, Lordship. I'm unable to take any instruction, Lordship. I have no instruction in the matter, Lordship.
No instructions.
71.
No instruction. No instruction.
72.
Dismissed.
Item 73.
Dismissed.
Item number 75.
Dismissed.
76.
My lord, may I please your lordship? I am in visit your lordship.
Yes,
Item 76. My lord, non-compliance of order dated 3/2/2016 passed in WPC number 4107 of 2006 and non-compliance of order dated 23/2/2017 passed in contempt number 1716 of 2016, your lordship.
Again, contempt order. Come to the petition.
My lord, here the then inspector of school, district inspector of school recommended the name of the petitioner school to give minimum granting rate in compared to the high school of Janmeja Carlo of Sambalpur district.
No, I'll not go into the merits. The question, the direction was only to consider whether your
My
case
lord.
needed or not.
My lord, they have not considered till today, your lordship.
Who is for the side? Who is there for the other side? Who has to comply with?
Commissioner come Secretary School and Mass Education.
Huh?
item कितने कब चलेगी? 6. Record नहीं होता.
Yes.
But the records are not available.
Two weeks time is allowed for the contenders to state as stated. The order of this court dated 3/2016 passed in WPC number. Also has been complied with.
7
Item 77.
27, no instruction.
No instruction.
77, I am for the petitioner. So no instruction. Huh? I am for the petitioner. He is appearing for the in contempt for the respondent and also the contempt. Some contempt. This second, I am paying your lordship the petition I take to read this. This will be directed to list before the this petition 7235 by 2010, which is a tag to the contempt that may be listed in the assignment because it is a matter relating to service benefit of the petitioner.
No, sir, this is not material. The writ petition has been disposed of.
No, this second one is pending, my lord.
Second,
the tagged writ petition 7235 of 2010 is pending, my lord.
You are alleging disobedience of which order?
My lord, obedience order that Sikans how is bedded in, my lord. For that reason, here
you are alleging disobedience of which order?
My lord, Mr. Sikansa, who is appearing in contempt with some.
So you want that?
My lord. In second writ petition, the writ petition type to I am appearing in that writ petition.
As requested on behalf of Dr. Ram.
78. Item 80.
No instruction.
No instruction.
81.
You can say, well, no instruction.
Sir, no instruction.
Item 82.
Dismissed. 84.
Item number 83,
Dismissed.
item 84,
Dismissed.
item 85,
Dismissed.
item number 86.
Yes.
Sorry.
Lordship for the petition. Lordship, in the present matter, the petitioner has approached this honorable court in writ petition.
You must be alleging violation of some order.
Your Lordship, Annexure 1. Page 38, Your Lordship.
86.
86, item 86.
Item 86, the next time.
86. Yes, which order?
Your Lordship, in Annexure 1, page 47. The petitioners are entitled to the following reliefs.
Yes, who is for the other side? So what is your grievance?
Your Lordship, Annexure 2 is a representation.
No, whether it has not been complied with.
Your Lordship, it
Yes.
is not even complained.
The records are also not complete.
2 weeks.
87,
Obliged, Your Lordship.
Dismissed.
88,
81 no instruction.
89,
That matter, the order has been complied with. An affidavit has been filed. You are AGA?
Marcus.
An AGA appearing on behalf of the contender states that this court's order has been complied with. There is no representation on behalf of the petitioner. Contempt proceeding stands stopped accordingly.
item 90,
No one appears. On behalf of the petitioner. It is, however, an affidavit has been filed. So-called affidavit has been filed on behalf of the contenders, from which it appears that this court's order, violation of which has been alleged in the present contempt application, has been complied with, though belatedly. First off, the contempt proceeding stands stopped accordingly.
91,
No instruction.
No instruction.
92,
Lordship 92 to 131. Lordship, some part of the order has been complied with. Some portion have not been complied with, Lordship. I pray for some time to get the instruction which part exactly has not been complied. There are certain benefits which has to be extended to the petitioner, so Lordship. So I will take the instruction. What are the
Let me see the order first.
Lordship? The order is that issue 1, Lordship, page 7. Operative question, Lordship, will be found. 27 and 28. Or 17, my lordship. Page 27 and 28. 17, my lordship.
Yes.
My lords. Your lordship may kindly turn to paragraph, the same order, page 11, running page 11.
Running page
18.
Yes.
Here's, my lords, pointed out that 12 my lords, benefits have not been granted to him. In CVA10, he has pointed out 12 benefits. Service book has not been opened, annual increment has not been given.
Almost all the benefits has been extended. Some of them has not been extended.
So that is not deliberate. If something has not been extended, then you can raise a claim. Not in the present.
The lordship may then grant me the liberty to.
No, that liberty I'll surely grant.
Sure.
Because see, in contempt proceeding, we have a very limited jurisdiction.
Right.
Just to see whether they have deliberately violated something. Even if there is any disobedience, the court may not interfere.
You lordship may see Anisha A1. They have filed a statement.
I'll give you liberty. The petitioners in the present batch of separate order as well. The petitioner in the present application has alleged disobedience of this court's order dated so and so. सबका अलग date सबका एक है. But petitions are so called affidavit has been filed on behalf of the contenders, from which it appears that this court's order has been substantially complied with. When counsel appearing on behalf of the petitioner, however, has asserted, submitted that certain reliefs are there which are yet to be granted by the contemners in terms of the said order of the court. Next, in the present set of facts and circumstances, and considering the reply, considering so-called affidavit filed on behalf of the contemners, I am not inclined to proceed in the present contempt matter. The petitioner shall, however, be at liberty to raise his grievance, his particular grievance, specific grievance, before appropriate authority of the forum. If such grievance has yet not been redressed.
Up to item
131, 92 to 131.
my appearance in all made recording, filing the wakalat also.
Item number 132. 132.
No one appears.
133.
No one.
134.
I'm sorry, my lord. I'm appearing in item number 132, my lord.
Yes.
My lord, here in this case, my lord, the petitioner paid for the compensation along with the interest, my lord. They have paid the principal amount, but they have not paid the interest, my lord.
Let me see the order. Where is the order?
My lord, I have quoted the order, my lord, as page 2, my lord. It was a direction to comply with the order of the Lokayut, my lord. And in page 9, my lord, the secretary, joint secretary to government wrote a letter to Collector Malkanagiri in para 1 towards last, my lord.
What is there? What is there in the order? What is there in the order?
My lord, there is a tender, my lord. There is a tender.
No, what is there in the order? What part of the order has been violated?
My lord, they have only paid the principal amount. They have not paid the interest.
Direction? Is there any direction to pay interest? Is there any direction to pay you any amount?
Yes, my lord. Yes, my lord. And my lord, kindly see page 10, my lord. Page 9 and 10, my lord.
No,
Page
no.
9 is.
There is the order. Show me from the order. I will not see anything other than the order.
But
My
he
lord,
was
it is.
the local order. He was not included in local order, my lord.
Lokai, where is the question of Lokai? Let us see the order first. To look into the grievance of the petitioner and issue necessary direction to immediate release of the amount involved. To
My lord.
He has to look into, might have looked into. We don't know.
My lord, they have only. My lord, kindly see their Sokas affidavit, my lord. They have prayed that they need 4 weeks more time to payment to the payment for the interest, my
There
lord.
was no direction for payment. There is no direction.
My lord, may I pray, my lord, to grant me liberty to approach my lord for payment of interest, my lord.
Following is the operative portion. Order dated 12/2/2015. Passed by this court in WPC number 20342 of 2012. Then senior counsel say.
My lord, I'm sorry, my lord. I'm appearing on behalf of Mr. S. D. Das, my lord, on a senior counsel. My power is not there.
Seeing something else. That part of the order is being quoted. When counsel appearing on behalf of the petitioner has submitted that though the petitioner has been paid, which amount? We have been paid
the principal amount, my lord.
The principal amount, interest thereon has not been paid. First off, there is no specific direction in the said order requiring the contemners to pay interest. Stop. And counsel for the petitioner has, however, relied on certain observations made by the Lokpal on the petitioner's complaint. Stop. Be that as it may, considering the nature of the order passed by this, no case of deliberate disobedience of this court's order is made out in the present set of facts and circumstances. Next, the petitioner shall, however, be at liberty to approach appropriate forum court for the redressal of his grievances.
133, they did touch.
133 and 134 is same, my lord.
133 and 131.
133.
But I'm appearing for the DRDA.
All right.
Part number MK Das for DRDA.
All right.
Item 135.
Both the matters.
135, my lord. The high Sokas applicable should die to supply me a copy of this Sokas. Lordship direct to dispose of representation, my lord. The Lordship can see my Sokas report administered A/2. That representation is disposed of since 2016, my lord. And that is also coming.
Challenge that order.
That is second contempt. First contempt order also filed. They have not complied with them. Second contempt. In second contempt, they filed Sokas. Copy not supplied to me. So they also died.
Take a copy if you want. Just for that reason, you want the matter to be adjourned. It's a different matter. But if the order has been complied with, an order has been passed, then let me see what is the order.
Yes. Lordship can see A/2, man.
Let's just
Also, I we told the we will also permit the liberty to file to challenge that.
All right. It is stated the bar that the sports order violation of which has been alleged in the present contempt application has been complied with, in as much as an order has been passed on the petitioner's representation by the Director Secondary Education. 2016. So, in such way of the matter, this contempt proceeding is dropped with a liberty to the petitioner to question the correctness of the order passed. Order dated 19/8/2016.
16, my lord.
16
I'm
of the director before appropriate forum in accordance with law.
I'm handing over the copy.
136. 136 is my lord. No instruction. 137.
This is against an order dated 13/2/2015 under Annexure 1, my lords.
This is against an order.
Yes, against an order, my lords. There was an interim order, my lords. If your lordship.
Where is the interim order?
Plus Annexure 1, page 7, my lords. Of the contempt, my lords.
Yes.
Yes, it was said that it is directed that there shall be stay of operation of the order dated 11/7/14 passed by Additional Commissioner of Consolidation and Settlement Sambalpur in Consolidation Revision number 779/11 and order dated 21/15 passed by Tahsildar in mutation case.
So what happened to this case?
Because while pendency of this, while this interim order was in operation, the private opposite party had sold off the property to.
Where is that? WPC, whether that is pending or not?
Because the writ is pending as of yet. The writ is pending, and because Annexure 3 is the registered sale deed.
Just it is stated by Learned Counsel for the petitioner that the writ petition that WPC number 2507 of 2000 is pending. First off, this in the present contempt application, the petitioner has alleged disobedience of an interim order passed by this court in WPC number 2507 of 2015. Stop this matter along with WPC number 2507 of 2015 before the assigned bench 4 weeks.
Lords, may kindly reflect one thing that I'll file fresh wakalatnama in this matter, my lords.
You can do that, whatever.
Lord, see, the opposite party is not a party in the petition, my lord. Opposite party to contempt, my lord. The deputy sub-registrar Baravar, my lord. He is not a party in the petition.
Yes, why so? Because he is the registering authority. Tahsildar was there in a party. He was intimated. Official records said that there is a stay on this property. But despite that, it was being registered and it was sold off, Milos. And hence.
So was he knowing that?
It was on record, Milos, that there is a stay of operation in this property.
How was he knowing?
No, Milos.
Then why have you implicated him as a party?
Milos, then I'll take necessary steps, Milos.
Opposite party too, my lord.
Milos, I'll take necessary steps.
138.
Dismissed.
Item 139. 140. 141. 142. Item number 143. 144. Item 147.
Same order.
148,
Same order.
item 149,
Same order.
150,
Same order.
151,
Same order.
152,
Same order.
153,
Same order.
155,
Please, your lordship, this is regarding the appointment of the home guard. In the meantime, they are giving the so-called reply. From so-called reply itself, it appears that in the year 2015, there were vacancy. But till then, I was not given. On the other hand, they wanted me to apply. That is not the spirit of the, that is not the intention of the honorable court.
Let me read.
That is the so-called on behalf of the opposite
No,
party.
where is the order?
Okay, my lord. Order is annexure 1. It is the
Annexure is something else.
second contempt. Hard Law and Counsel for the petitioner, it is stated that the order dated 13/1/2016 passed by this honorable.
Where is the order passed in the writ proceeding?
I have not annexed that order, but that is, they have quoted it in their so-cause. Let me take profit, read out this. The Commandant Home Guards, Rayagada, is directed to consider the case of the appellant for appointment as a home guard if there is vacancy in the district, if he submits application in prescribed form A as per Rule 4 of the Odisha Home Guards, Rule 962. 3. If he is found suitable meeting all requirements and qualifications including age, medical fitness, physical efficiency test, and has good character and antecedent, etc. As per Rule 3 and 9 of the said rules, paragraph number 13 of the Home Guards Compendium, Instruction 2007, issued to the Government of India.
So come to paragraph 7.
In the 7, they have specifically admitted that it is humbly submitted that in the year 2015, there were a number of vacancies of the Home Guard in Rayagada district, and accordingly on 16/17/11/2015, the recruitment board was held for selection of Home Guards. The petitioner did not appear in the said recruitment board, for which his reappointment in the Home Guard organization could not be considered. I am not expected to appear that interview.
Yes.
I have got a right to be considered because once I was selected,
Yes.
finding me fit in all respect, they selected me, but subsequently I was terminated, discharged. And thereafter, they say that they have made a drive for appointment. So anybody
Where
can
is the
appear.
order of the appellate authority?
Yes, my lord.
Where is the appellate order passed by the Commandant General?
No order has been passed.
Please come to the order passed by this court, which has been quoted in the so-called affidavit.
On the Commandant Home Guards, just I read out.
Please come to paragraph 5.
Prior to the said order of the Honorable Court, 14/7/2017, by order dated 13/1/2016, the Honorable Court had disposed of the writ petition WPC number 379 of 2016 with the following directions.
This was the direction. This was the direction issued in the writ petition.
Yes, my lord.
What is that direction?
Considering the contentions raised by the Law and Counsel for the petitioner, this court disposes of the writ petition, directing the opposite party number 3 SP Commandant Home Guards Rayagada to consider the case of the petitioner in view of the appellate order passed by the Honorable Commandant General Homewards, Odisha High Annex 2 within a period of 4 months from the date of communication of this order. They have not passed any such order. Thereafter, they have not passed any such order.
Where is the order of the Commandant General? See, the SP come commandant was required to pass an order in the light of the order passed by the Commandant General. Where is the order passed by the Commandant General?
My lord, I want 7 days time.
As requested on behalf of the petitioner, list this matter on 1 week. In the meanwhile, find out.
Smile.
Yes.
Next week.
156.
Lord, 156 my lord, on behalf of Mr. Mahapatra my lord, already complied my lord order.
Complied.
156 to 159 all are complied.
156,
157, 158.
157, my lord. Page 8, my lord, order now. In view of the matter, without extracting the option of the merit of case, the writ will be.
no, these orders have been complied with.
Complied my lord. I have filed already SOPAS my lord. Annexure D to the SOPAS, I have complied my lord.
So the order has been complied with.
No, my lord, no order.
Liberty rejected. His claim has been rejected.
Yes, my lord. Rejected my lord, in a sense, my lord, we have asked government, if government is providing the post my lord, then we are going to regularize them. We are going to regularize them if government allows us the post my lord. 156, 157, 158 and 159.
Liberty, my lord.
Yes.
160.
My lord, name of Mr. Mahapatra my lord.
161 no instruction. No instruction.
161.
Yes, Mr.
162.
Yes.
164.
Yes, Mr.
165.
Yes, Mr.
166. 165.
AD has not returned and counter has also not been filed.
Whether order has been implemented or not?
My lord.
Implemented.
No, order has not yet not been implemented.
How do you know? How do you know that order has not been?
Nothing has been communicated, my lord.
Not communicated. So your client has communicated to you.
My lord.
Whether your client has told you that order has not been complied.
Yes, my lord. Today I got it.
Today. Yes. Where is the order?
My lord, there is neither radio nor SOCOS, my lord. Then I will file give some time. 1652.
Yes, 2 weeks, 3 weeks.
My lord. 166.
Thanks. 3 weeks. Time is allowed for land AG and file. Suppose affidavit on behalf of the contenders. Yes.
166. No one is there.
No one. Dismissed.
167.
Come on.
168. 169.
So the interim order passed by this honorable court has been violated by the writ petition has also come.
So
This
the
honorable
petition is
court-
pending.
Writ petition is pending. It has also come in the list. It is there in the list.
No, it will go before the assigned bench. This contempt petition arises out of an interim order passed in WPC number 794 of 2014. Let both the matters be listed before the bench, before the assigned bench.
Item 170.
No one appears.
171.
No instruction.
No instruction.
Item 173.
No instruction. No instruction.
173.
172.
173, sir.
My lord, 32, no instruction. 173, yes, sir. Yes, my lord. This is violating the order date of 5/7/2006, 17, my lord. Page number 10, the read petition order is there. And the operating party is page number 16. Para number 8, my lord. Applying the above principle is laid down by the appeals court to the present content also region assigned therein. The opposite party note is directed to necessary correction in consonance with the syllabus prescribed for the NRTC examination 2016 and recompute the marks due and administrative. What is NRTC? NRTC is, my lord, national.
We don't have to follow it. 73.
And manner further directed that to recomplete the marks as due and admissible to the petitioner as expeditiously as possible, preferably within 4 weeks, my lord. And my lord, thereafter they not complied and filed a contempt petition. And that also not complied. Thereafter, I filed a second contempt before this lordship. And yes, my lord. What is the order? You are not in a position to tell me what is NRTC. And then come to the order applying the above principle laid down by the court. And also reasons assigned there in opposite party number 2 is direct to make necessary correction in consonance with the syllabus prescribed for NRTC examination. This examination was what? And this is the examination for the National Rural Talent Search Examination. The National Rural Talent Search Examination is over, is of 2016. Yes, my lord, I've given the examination now. My lord, I've given the examination and the one and they marked one mark. In one question, they marked the wrong answer. Maybe thereafter, can be done. What will you get now? This order was passed in 2017. We are in 2024. This was 5th July 2017. We are on 5th July 2024. We are just this order. After this content, they filed a show cause over the show cause. And in show cause, they said that the writ appeal they filed the challenge the writ petition order. That because of the writ appeal, they didn't take any action to comply this order, my lord. And meantime, my lord, the writ appeal order will dispose of by this court. Disposed of by what order? Where is that order? Order is not with me, my lord. Then what happened? Who is appearing?
I am appearing, my lord.
Yes.
That this order was complied with.
Not complied, my lord.
Yes,
No,
this
no, no, my lord.
This was complied with after giving that mark, he was communicated everything.
I'm not, but yeah.
We have communicated.
I'm not received any copy from. Seek instructions. You may not be knowing. My lord, I received the instruction, did not receive any instruction, copy of the from the side of the court, my lord. Just if any copy, my lord senior have then list this on next Friday. Please bring on.
I will supply. I will supply copy to him.
Portland senior counsel appearing on behalf of the petitioner to hand over copy of the decision by decision taken by the contemners in compliance of this court's order, to learn counsel for the petitioner. No place.
174,
Dismissed.
175, 176,
Dismissed. Why not 174? The matter is compliant, my lord. Compliant, yes. 174 compliant.
177,
Dismissed.
178, oh, nothing.
No, it's dismissed.
179,
179 complied with.
Yes, sir. Compliant, yes.
180,
Dismissed.
181,
Dismissed.
182,
Already complied, your lordship.
Complied with. Complied.
183,
No instruction, your lordship.
No institution.
184,
Dismissed.
185,
Dismissed.
186,
Dismissed.
187,
Dismissed.
188,
Dismissed.
189,
Dismissed.
190,
Dismissed.
191,
Dismissed.
192,
Dismissed.
item 193,
Dismissed.
194,
Complied, your lordship.
Complied.
Your lordship, 184 also complied. 184 also complied.
195,
Complied, my lord. Complied.
196,
Dismissed.
197, may I please, your lordship, I am appealing through VC.
Yes.
195 complied, your lordship.
197, 197, my lord, infructuous, your lordship.
Infraction.
198,
Complied.
Complied, your lordship.
Complied.
Complied.
199,
199. Dismissed.
200,
Dismissed.
may I call the arbitration matter.
May, your lordship, pardon my lord. If it's not increment to your lordship, item number 283, because I got personal difficulty on next Friday. 283 is the interlocal matter, the writ application is pending, also listed today. So as your lordship passes the order,
Wait, it will go. Oh, it will be listed along with the writ petition.
pardon my lord.
Your contempt petition and writ petition shall be listed before the assigned bench.
Oblige, I'm sorry for disturbance.
Plus, I beg your pardon, my lords. Sorry to intervene, my lords. Plus, item 426, 423, and 464 of today's board, my lords. These are three content, my lords. It has been partly complied, my lords. This is a case wherein 20 months area salary was admitted, my lords. 13 months salary has been paid after the order passed by this honorable court. Only 7 months salary is yet to be paid, my lords. If your lordship may take up
No,
this.
was there any specific direction? If
No,
there was any specific direction,
Specific direction for 20 months, they paid 13 months and 7 months is yet to be paid.
no,
my lords.
we'll see. The next state. Yes. And who has to pay?
It is INPA department and NIC, Information and Public Relation Department.
Give the case number to Mr. Satnaik.
arbitration matters.
Also supplementary IRB.
Thank you.
Yes.
Press admission item number 1, ARBP 18 of 2024. May I please, your Lordship? Lordship was hearing this matter on the last week on the question of territorial jurisdiction. My learned senior had referred to a judgment. I had referred to a judgment of the Honorable Supreme Court that venue will not confer jurisdiction on the court. My learned senior had referred to a judgment of the Supreme Court in 2000, reported in 2020. That was a two-bench judgment where, in the facts of that case, the court held that it will confer jurisdiction. But subsequently, a three-bench judgment comprising the same quorum, and in fact I have filed that judgment also. That judgment has also held three-bench judgment that venue will not confer jurisdiction on the courts. That is flag 2, your Lordship may see. That judgment also that is a subsequent judgment and is a three-bench judgment. And in the other judgment which I was also relying on, that has also relied on another three-bench judgment of the Honorable Supreme Court. So, in my humble submission, the three-bench judgment will be binding, and
all right, I'll consider.
Yeah, may I submit? There's a different aspect to what my learned friend submitted. All three judgments doesn't have any application. Lordship may kindly see section 20 of the arbitration constitution for a moment.
Yes.
Section 20 postulates three scenarios. There are three subsections. First subsection speaks about the party autonomy, which is paramount. Parties are free to agree on the place of arbitration. That's a party autonomy. Second, failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. When the parties are not agreed, then the arbitral tribunal will decide the venue or the seat of the arbitration, which will have an impact on the jurisdiction of the court having supervisory power over that arbitral tribunal below. There is no party autonomy. So arbitral tribunal decides the seat of the arbitration venue. Thereafter, that particular court will have the supervisory.
In that case, when section 2 comes into play, then arbitral tribunal can sit one day in Cuttack.
So that is 3.
The other day in Delhi.
That is sitting of the arbitration. That's a 3. The subsection 3 says, notwithstanding subsection 1 or 2, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place and considers appropriate for the consultation among its members for hearing witness, experts or the parties, or for inspection of documents, possession of the property. Yes. Subsection 3 is the seat of the sitting of the arbitration, not the seat of the arbitration.
Yes.
So 2 comes into play when the 1 is absent. Yes. The first judgment which my member friend submitted for a consideration, that is on the 22, if not so time we see. Yes. The compensation judgment, last date, my member friend says, submitted, that is the BDR India Private Limited. Like in there, the dispute resolution clause was that the parties had not agreed. So the arbitral tribunal decided the seat of the arbitration considering the other clauses of the agreement. That is what the judgment speaks about. But I will read the relevant portions. If you also may kindly see paragraph 22 of the same judgment, BDR India. My understanding relied on the page, paragraph 37. So that also I will show to you, Lordship. But before that, paragraph 22. Lordship,
yes.
DGS SGS SOMA extensively refers to the judgment of this court in Indus Mobile Distribution, which decision refers to the legislative history of section 2(1)(e) and section 20 of
what is the ratio according to
the ratio is that when the section 20 subsection 1 is absent, when the parties have not agreed the seat of the arbitration, then the arbitral tribunal, here also in this judgment relied by my understand, the Honorable Apex Court says that party had not agreed to that. In absence of the agreement by the parties, the arbitral tribunal will decide.
then once the arbitral tribunal decides the seat of the arbitration, that only court will have the jurisdiction having supervisory power. This is what the crux of the entire judgment, you know. Even in the paragraph 23, they will clearly say, in the context of the domestic arbitration, you know, I am reading 1, 2, 3, 4, fifth line of paragraph 23.
Yes.
In the context of the domestic arbitration, it must be held that once seat of arbitration has been fixed, then the courts at the said location alone will have exclusive jurisdiction to exercise the supervisory power over the arbitration. The courts at other
Which paragraph you are reading?
Well, it's the paragraph 23, fourth line, my lord.
Yes.
In the context of domestic arbitration, yes. In the context of the domestic arbitration, it must be held that once the seat of arbitration has been fixed, then the courts at the said location alone will have exclusive jurisdiction to the exercise of supervisory powers over the arbitration. The courts at other locations would not have jurisdiction, including the courts where cause of action is arising, as observed above and held in BGS, SGS, SOMA, and in this mobile. The moment the parties by agreement designate the seat, it becomes akin to an exclusive jurisdiction clause. It would then vest the courts at the seat with the exclusive jurisdiction to regulate arbitration proceedings arising out of the agreement between the parties. Now, my lord, the paragraph which my mention rely, paragraph 37. So there also they are saying the same thing. In absence of the agreement between the parties, may I place that paragraph, the same paragraph which my friend relied on. We have already referred to the first few sentences of the aforementioned paragraph and explained the reasoning in the context of the present case. The paragraph in BGS, SGS, SOMA also explains the non-obstructive effect as incorporated in section 42 to hold that it is evident that the application made under part 1 must be to the court which has jurisdiction to decide such application. That the seat is designated in the agreement, the courts of the seat alone will have the jurisdiction. Thus, all the applications under part 1 will be made in the court where the seat is located, as that court would alone have jurisdiction over the arbitration proceedings and all subsequent proceedings arising out of the arbitration proceeding. The quotation also clarifies that when either no seat is designated by an agreement or the so-called seat is only a convenient venue, then there may be several courts where a part of cause of action arises that may have jurisdiction. And application under section 9 of the Act may be preferred before the court in which a part of cause of action arises in the case where the parties have not agreed on the seat of the arbitration. This is possible in the absence of an agreement fixing the seat, as an application under section 9 may be filed before the seat. It is determined by the arbitral tribunal under section 20 subsection 2 of the Act. So my case is on the section 20 subsection 1 where the parties have agreed to confer jurisdiction. So this doesn't apply. The second judgment when I mentioned is relied on again now, Mantasu impact Miller. There in this second judgment, the facts were that there were two separate clauses. One was related to the venue of the arbitration, other was related to the jurisdiction of the court. But here parties say that the arbitration will be held in Hong Kong, whereas the New Delhi court will have the jurisdiction. So where there are two contradictory clauses are there, then the apex court say that court while appointing this arbitrator need to consider the other contents of the agreement to drive the intent of the parties. Here also the section 11(6) was dismissed by the Honorable Apex Court in this judgment, paragraph 28, the last paragraph. So before that, you also may kindly see what were the clauses. Not while appointing under 11(6), the arbitration clause is very important how they see it. So paragraph 17, if you also may kindly see the second judgment. 17(1). 17.1, you also got me?
Yes.
This MOU is governed by the laws of India without regard to its conflicts of laws, provisions, and courts at New Delhi shall have the jurisdiction. That's one part. 17.2. Any dispute, controversy, differences, or claim arising out of relating to this MOU, including the existence, validity, interpretation, performance, breach, termination thereof, or any dispute regarding non-contractual obligations, arising out of or relating to it shall be referred to and finally resolved by the arbitration administered in Hong Kong.
Yes.
So there are two separate clauses relating to the arbitration and jurisdiction. There will not the Honorable Apex Court said, paragraph 20, which is relied by my learned friend. That is where they say that when there is no clear-cut intent of the parties, then the 22 comes in. So here also, paragraph 28, the last paragraph you also may kindly see, the result. Paragraph 28, madam.
Yes.
So in the result, arbitration petition number so and so filed by the petitioner seeking appointment of an arbitrator under section 11(6) of the Act is dismissed. It is however open to the petitioner to approach the Hong Kong International Arbitration Center for appointment of the arbitrator if they so desire. So where the arbitration agreement parties agreed to be held at Hong Kong, the Honorable Supreme Court did not consider the jurisdiction of New Delhi but held that the arbitration was decided by the parties who go to the Hong Kong. Now the third judgment, Ravi Engine Developers, is relied by Madam Friend. Well, there if also may kindly see paragraph 3, the arbitration clause. It is quoted there that in case of any dispute or differences between the parties arising out of and relating to this development agreement, the same shall be settled by reference to the dispute or differences to the arbitrators appointed by both the parties, and such arbitration shall be conducted on the provisions of the Indian Arbitration Constitution of 1996 as amended from time to time, and the sitting of the said arbitral tribunal shall be at Kolkata. This falls in the subsection 3 of section 20. This was the seating of the arbitration. The seat or place of arbitration was never decided here by the parties. Now the subsection 3 says when 1 and 2 is absent, then the sittings they anyway can decide taking into account of the convenience of the parties or the convenience of the even the arbitrators also, where the international arbitrators also joining in the arbitral tribunal, for recording the evidence and everything, they can, as you lordship, the opening statement will lordship say that they can move to other places. That is 3 sitting of the arbitration decision. So this has absolutely no application to this cases in hand. Then when you last time asked me that the Brahmani River was considered by, it was considered in this judgment itself, the BBR judgment.
Yes.
Now you also may kindly, our Honorable High Court, in a similar matter, has explained section 21(2)(3) and also
yes.
Well, paragraph 6, the arbitration clause was quoted in paragraph 6.
Yes.
Yes, in order to appreciate the rival submissions, it is deemed appropriate to reproduce clause 15.3 of the dealership agreement, which reads as follows. All dispute arising out of execution or in relation to this agreement shall be settled amicably through friendly negotiations between the parties. If a settlement cannot be reached, any dispute, controversy, or claim arising out of or in relation to this agreement, including the validity, invalidity, breach, termination thereof, shall be referred for arbitration to sole arbitrator appointed by the managing director, CEO of the semi-heavy industries. Place of arbitration shall be at Pune. Language of the arbitrator proceedings shall be in English. So this falls under 21. This party categorically agreed that the place of arbitration shall be at Pune. So that's why this under the paragraph 9.
Yes.
A plain reading of section 20 leaves no room for doubt that where the place of arbitration is in India, the parties are free to agree to any place or seat within India, be it Delhi, Mumbai, etc. In the absence of the parties' agreement thereto, section 20 subsection 2 authorizes the tribunal to determine the place of the seat of such arbitration, and section 20 subsection 3 enables the tribunal to meet any place at any place for conducting hearings at a place of convenience in the matters such as consultation among its members for hearing witnesses, experts of the parties. The next paragraph. An identical issue came up before the Supreme Court in the case of Swasti Gas Private Limited versus Indian Oil Corporation. In that case, the respondent, Indian Oil Corporation Limited, appointed Swasti Gas. But the Swasti Gas may not the same falls under the 21. The parties had agreed that the jurisdiction shall be at Calcutta, but the word only, some, exclusive, these words were not there earlier. So Swasti Gas for the first time that the Honorable Apex Court said that these words, in absence of these words, doesn't make any difference. So once the party, the intent of the party to go to a particular place for the arbitration matters, so in absence of these words also doesn't make any difference. That is the entire Swasti Gas judgment. I'm not taking through the video. Then we'll have paragraph 13 of this judgment, our Honorable High Court. 1-3. The Supreme Court in recently delivered decision in Brahmani River Connects considered whether the Madras High Court could exercise jurisdiction under section 11(6) of the Act to appoint a sole arbitrator at the instance of the respondent, despite the fact that the agreement contains the clause that venue of arbitration shall be Bhubaneswar. Where the appellant challenged the said order by questioning the jurisdiction of the Madras High Court on the ground that since the parties had agreed that the seat of arbitration shall be at Bhubaneswar, only Orissa High Court has exclusive jurisdiction to appoint the arbitrator. The respondent argued before the Supreme Court that since the cause of action arose at both the places, that is Bhubaneswar and Chennai, both Madras High Court as well as the Orissa High Court will have supervisory jurisdiction. It was argued that in domestic arbitration, unless the parties tie themselves to an exclusive jurisdiction of the court in the agreement, mere mention of venue as a place of arbitration will not confer exclusive jurisdiction upon that court. It was also submitted that mere expression venue of arbitration shall be Bhubaneswar will not confer exclusive jurisdiction upon the Orissa High Court, particularly in view of the definition of court as stipulated on section 2(1)(e) of the Act 1996, which confers power on the principal civil court in original jurisdiction in a district and includes the High Court in exercise of its original jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration. If the same had been the subject matter of a suit, the Supreme Court relied on the Constitutional Bench decision of Balco, repelled the argument in para 16 and 17 of the report in Brahmani River while observing thus. So they relied on the Constitutional Bench of this Honorable Apex Court, the Balco judgment. When the Brahmani River Miller last time what I submitted, that squarely falls in section 20 subsection 1, because in this agreement, this case in hand, parties have categorically agreed, unambiguously agreed that the Delhi court, the place of arbitration shall be at New Delhi and to be conducted by the Indian Council of Arbitration. So all three judgments cited by my learned friend does not be applicable to the particular case only. The second aspect of this matter is that if you last may kindly see the agreement that I have mentioned in my application also. But the entire issue what the petitioner is raising, the dispute, so-called dispute, I would say that this petition is a premature one. The second link of my argument is, first is this Honorable Court does not have jurisdiction. Second, the application itself is a premature. Why? Because his contention is that the subsidy of interest which was agreed by the government or the respondent, that was withdrawn.
Who is the respondent?
National Skill Development Corporation. National Skill Development Corporation. So the interest subsidy was linked to the performance. He had taken the money, the loan from the respondent to establish the training centers across India to give skill trainings. That performance in this agreement, the performance parameters were given. But this has to be the performance parameter. That was not there. So what is the fallback of that? That is given at page 29 of the petition. That is clause 5.2. It says, "Well, on the happening of any of the events of default, the lender shall give a written notice to borrower to rectify the default within a period of 45 days. In case of default is not rectified within a period of 45 days, then the lender shall have right by a notice in writing to the borrower without prejudice to the rights and claims under this agreement to terminate this agreement or decline the principal of or the interest on all of the other amounts given." So first, I had to give a notice during a 45 days time to rectify or to improve the parameters as given agreed in the agreement. Failing which the agreement will be terminated, recalled. Then the dispute will be there, how much amount he has to return back. So today, in the application, my application challenging the maintainability, I had issued a notice and I have annexed that also, page. That is annexing 1, a copy of the notice of dispute, page 10. So on 9th May 2024, I served a notice to him, asking him to improve the performance within 45 days, rectify the mistakes, whatever. Failing which, I need to take the action in view of the clauses of the agreement. When the dispute will come, when I take the action, that is in consonance with the agreement or not, then the dispute will arise. So today, he has to improve the performance. Failing which, my right accrues to take action.
So what is the dispute according to him?
Well, dispute is that he is saying due to corona, I could not. It's an admitted fact that the performance was not up to the mark or agreed by the parties in the agreement.
So that is not the dispute. That may be his stand. That because of corona, I could not do something. But what is the dispute?
The dispute is, well, since I could not improve the performance or the best performance, the interest subsidy was withdrawn by the respondent. So today, if we improve the performance, which is the interest subsidy which was withdrawn, that can be considered.
No, that is the dispute. That is the dispute.
Well, dispute.
It is not that your submission that there is no dispute and therefore this application is premature. That may not be correct because that is the dispute. He is raising there is some dispute. Any dispute can be raised to arbitration.
Any dispute in the sense, what is the dispute that I admittedly could not perform according to the agreement, so the interest subsidy withdrawn. I said that, okay, I am giving time to improve the performance.
So you write to him?
I wrote
He
him.
will not withdraw.
No, I wrote to him, giving time to.
You give him that if you do it, I will not withdraw.
So that is the 45 days notice I have given.
Notice, what have you mentioned that you will not withdraw the subsidy?
That has already been withdrawn.
That has already been withdrawn there.
Yes.
That is the dispute is there.
My submission is that withdrawal is linked to the performance, and for performance, time is given to him.
And he has some explanation.
Well,
Therefore, some dispute. So that aspect, your first submission, yes, prima facie, that appears to be correct. I'll have to examine.
an agreement also signed in the major
So far as the objection on premature dispute, the arbitration clause,
Premature, I'm not convinced.
because the arbitration clause says any dispute, not that.
Premature, I'm not convinced, but he appears to be right in his submission that
So far as
court does not have
so far as the jurisdiction is concerned, the last judgment which was the judgment which was relied on, the relevant paragraph here, my learned senior not placed now. My learned senior submission is that venue and seat of arbitration is the same thing. But the Honorable Supreme Court has held that no, both are separate. In this case, only the venue has been mentioned as Delhi. Seat is not mentioned. So that is what the Honorable Supreme Court said, that when
can the seat be beyond venue?
Yes, my humble submission that has been held by the Supreme Court, because seat can be, Your Lordship, as per section 21E of the Arbitration Act, where the cause of action arises, and then it relates to section 20 of CPC, wherever a part cause of action also may arise. That court also may have.
I'll see.
Good.
I'll read those judgments and then.
Oblations.
So that in the Brahmana River, they have taken care the interplay between the seat of the arbitration and the place of the arbitration. In the judgment paragraph 17, they have mentioned it.
Just give the relevant paragraphs. You both.
I but you said file a short note mentioning on.
You also.
Yes, madam.
Right, you will.
Well,
Yeah, I may dictate the order in the court.
Well,
item number 2.
May please, Your Lordship. May please, Your Lordship. Lordship, we have filed this petition seeking for appointment of an arbitrator, Your Lordship. The service agreement is at page number 37 of the brief, Your Lordship. If I may take Your Lordships to the relevant page, Your Lordship.
Notice will go at least.
Yes, Your Lordship.
Notice will have to go.
Yes, Your Lordship.
So arbitration agreement is there.
Yes, Your Lordship.
You had put to notice the other.
Yes, Your Lordship. We have served in the notice.
Issue notice.
Item 3.
Much obliged.
Item 3.
Yeah, please, my lord. Well, this is for appointment of an arbitrator, my lord. The arbitration clause is that.
Yes, formalities have been completed.
My lord, formalities have been completed.
Or issue notice.
For order item 4. 4 my lord, I am prefer an adjournment. Prefer an adjournment. Conducting count.
Oh, yes, that change of arbitrator.
Yes, my lord. Conducting council.
I am also seeking adjournment. Next. Item.
Item number 5. So there is an interim order in the matter. Item 4.
Interim order is there.
There is an interim order. my lord.
All right, interim order, if any, shall continue in the meanwhile.
Item number 5. I'm grateful, my lord.
Item number 5, the notice has already been issued, Your Lordship, but it is returned unserved for the reason that addressee could not be found. I may be allowed 1 week time so that I can reassure the address and I can file the notice requisites. If at all fresh notice has to be issued.
Yes. Service. Yes.
Item number 6.
Item number 6 should also be the IUFA amendment that has to be allowed, Your Lordship.
Lordship, I am appearing for the petition. We have filed an IE to include OMC as a necessary party. Your Lordship, as per your last direction, you have solved a copy on the opposite counsel.
That can be allowed, Your Lordship.
Lordship,
IE number. This application has been filed for impleading Odisha Mining Corporation Limited as opposite party number 2.
Opposite party 1 can be deleted also. There is no existing, there is no legal existence of OP1.
Opposite party number 2. Opposite party number 2. So, taking into account the nature of dispute raised in the present case, this application is allowed. So and so is implemented as opposite party number 2. Yes. Let so and so be implemented as opposite party. Yes.
We'll file a wakalatnama and on the next day to
Unless this matter on. Mr. You have received notice.
Your Lordship. I have to get the instruction from OMC, Your Lordship.
Instructions to receive notice in this case on behalf of the added opposite party.
Your Lordship.
Because he seeks adjournment to file wakalatnama.
Right.
Place this matter on 2 weeks.
Item number 7.
May, please, madam. Here, my lord, the notice was served, my lord, Satya.
My lord, I'm appearing this case. My learned friend has paid for appointment of arbitrator. The claim amount is around 1.5 crore. My lord, may I appoint any senior advocate?
Senior advocate.
As an arbitrator, Your Lordship, so that the dispute can be resolved.
You suggest names. Both of us. This one. And
Mr. D.P. Nanda, my lord, senior advocate, Mr. D.P. Nanda. Durga Prasad Nanda.
Durga Prasad.
If my learned friend doesn't have any of.
No.
but his name is not there in the list.
I suppose it must be there, my lord.
Is it there?
Please. Because I am already, this honorable court has already appointed in so many cases. And we're also conducting a case before him.
Instruction in this matter. Annexure 7. Annexure 7. The office of the Chief District Veterinary Officer, Punjab Borough of Williams, has stated the Chief District Agriculture Officer, Deputy Director Horticulture, District Manager, DDM, Deputy General Manager, DIC, and District Fishery Officer. Visit the project sites of the aforementioned date as a member of district level scrutiny subcommittee for final evaluation.
Not there. My lord, can we suggest another name? Sure, can I? Not there.
It is not there, Mr.
My lord, can I suggest another?
Yes.
Senior counsel, Mr. Subir Palit, my lord.
Yes, ma'am.
His name is there. You should have the.
But there, his name is also not there, my lord.
Not there.
In the panel, but they are doing arbitrations, my lord.
No, they can do arbitration, but not under the.
Each arbitration. Fix what you do. Yes, my lord may fix them.
The next state we will consider. Think of.
My lord may suggest, my lord may suggest.
No, I'll not.
I suggest them.
Sorry. You should list on.
We don't. This, my lord,
Uploaded in those.
because
That is uploaded on the website.
we thought that they've been appointed, so we suggested.
Ask them to get registered.
My lord, Mr. Palit is here. He is here only.
No, there is no question of applications, just.
Then we'll see.
Next slide.
Appointed by some president of party. So I'm conducting one arbitration. First place leaders according to non-match. That's all.
We'll look into the list and my lord will come up.
Item 8.
My lord, I am appearing on behalf of the petitioner, my lord. This is an application under section 11 for appointment of an arbitrator.
Yes.
My instruction is that the matter is at a very advanced stage of negotiations. Almost all the issues have been resolved, excepting maybe one or two issues. So given some time, managed 2 to 3 weeks, possibly the matter can be resolved out of court. If it doesn't, then it can go for arbitration. That's what.
Yes, Mr. Ghosh, do you have any?
Yes, the information is also like that to me, but the negotiation is continuing for the last 3-4 months, but it is not coming to an end. So at this stage, when my learned senior counsel, Mr. Palit, he knows well that we have also contesting these issues before the learned district judge under Section 9. So the process is on. There is no doubt of it, Lordship. But the point is, I would humbly pray the Lordship kindly allow 7 to 10 days time. By this time, they should come to an
2
settlement.
weeks. 2 weeks.
2 weeks is okay, Lordship, but it should not exceed that. My Lord, I shall be humbly praying because my entire material is stuck there. Few crores rupees my material they are utilizing my infrastructural facilities. Everything is being held up by them. For the last few months, since August 2022, this process is continuing, Lordship. I had to take a protective order under Section 9, but still then there is no relief. So I would humbly pray, Lordship, 2 weeks is okay, but they must come up with some solution, Lordship.
As jointly requested on behalf of the parties, the matter is adjourned to 2 weeks, expecting some amicable resolution of the dispute in the meanwhile.
Great. Item 9.
Item 9, my lord, on behalf of Mr. Tripathi, I pray one at time to I'll reply.
1 week.
Grateful.
Obliged.
Item number 10. Item number 10, I have filed Vakalatnam on behalf of the opposite party. Will file counter, Your Lordship. This will file the counter. 3 weeks time may be given.
3 weeks time is allowed for the opposite party to file counter affidavit. Yes.
Item 11.
Yes, please, Your Lordship. But they have been solved, the party has already been solved in notice of the. So may I suggest to me, Your Lordship, that to appoint an.
Who is for the other?
I am for the petitioner.
You are for the petition. I am for the petition. You are in 11.
11. Patito Pawan Mishra. ARVP number 12 by 24.
11. You are before 11.
Or 11.
That was item 10.
Mine. Item 10. But item 10, I mean item 10, I'm sorry.
So he has sought adjournment for filing counter affidavit. It will come after 3 weeks.
The opposite party. Well.
Item 11.
Yes. In this matter, there was an application for appointment of arbitrator. As per the last order, the requisites have been filed and the notice has been issued.
So whether other side has appeared?
No, there is no feedback from the opposite parties.
Huh?
No feedback. We have received any, not any.
Notices must have been served. No.
No. Not yet is done for. Only part of it.
My humble submission
Take
is
fresh steps. Take fresh steps for service of notice.
again.
Let fresh steps be taken for service of notice upon OP upon the opposite parties. Requisites 2 weeks.
Yes.
No. 8 weeks.
Item 12.
Item 12, Your Lordship, already requisites have been filed. And no one has appeared yet.
You are for whom?
I am for the petition matter. Indian Oil Corporation.
Service of notice.
Sufficient value.
So,
Yes, sir.
who is the other side? Janavani Fools.
My lord.
So. कब सर हुआ नोटिस? When?
Staff is lost in what office note declared 27th June. Yes. Our office. 7th June, office note is a very surplus.
2024. Despite valid service of notice upon the opposite party, there is no representation. It's all. Let the registry verify whether any wakalatnama has been filed on behalf of the opposite party or not. Stop awaiting appearance of, if not, awaiting appearance of the opposite party. Let's this matter on 3 weeks.
My lord.
Item 13. Let's, item 13, notices was issued on 25/2024. Your Lordship, I have got instructions to appear for the opposite party, and I have not filed the power till yet. So, Lordship may grant me 2 weeks. I will file Wakalatnama and the objection also to this matter.
Mr. El Mahapatra and counsel states that he has instructions to appear on behalf of the opposite party. So he seeks adjournment to file Wakalatnama within 2 weeks. Stop list this matter on 2 weeks.
Grateful. For pleasure. Item 14.
My lord, counter copy is not served.
Counter has been filed.
Lordship, I'm serving the copy.
Copy of the counter affidavit filed on behalf of the opposite party number 1 has been served in the court today on learned counsel for the petitioner. Does this matter on when?
So 1 week time.
1 week. All right. This is about, are you opposing?
No, Your Lordship, only the question of limitation. That's the only the question. Small.
All right.
Item 15.
Your Lordship. Lordship, I'm uploading for the petitioner. Lordship, notices has already been served. Lordship, in this matter, presently all the activities of the trust has been hold and on hold. Lordship, all the bank accounts has been frozen by the opposite party. And due to this dispute and disagreement also, as a result, the petitioner and all the 50, all the trust.
No, you want appointment of it?
Yes, Your Lordship. Yes, Your Lordship.
So who is appearing for the other?
My lord, I am appearing for opposite parties, my lord. My lord, due to 2 reasons, this petition is not maintainable in the IF law, my lord. Because petitioner has suppressed the material fact documents and filed the false affidavit before this honorable court. What material facts, my lord? My lord, I have filed the subsequent amendments of the trust deed, which he has not filed before which he has not brought before this honorable court with the clean hands. My lord, under annexure A series.
So you have filed your counter affidavit?
Yes, my lord. And my lord,
do you dispute that there is dispute?
No, my lord. He is alleging that I have siphoned the trust money, whereas the one civil suit is pending that petitioner has manipulated the trust document and taken the money for his personal benefit. And my lord, prior to this petition, my lord, the notice to appointment of arbitrator has not been served to the opposite parties, which is the mandatory provision under section 21 of the Arbitration Act.
Have you seen the counter affidavit?
Your Lordship.
He is taking a plea that before filing of this application, you did not serve a notice. That is mandatory. So if you have not served, then your application cannot be entertained.
Your lordship, I will take instruction regarding that.
That is the, if
Not-
that is there, then the court.
Not only that, he has filed the notice with this application.
Your lordship, I will take instruction regarding that. I will take
Okay.
instruction.
See, you should have filed.
Your lordship,
Non-counsel
I will take
for
instruction.
petitioner seeks instruction. Counsel for the petitioner seeks adjournment to seek instructions and file reply to the affidavit which has been filed on behalf of the respondent on behalf of the opposite party in opposition to this application for appointment of an arbitrator under section 11(6) of the Arbitration and Conciliation Act. Yes.
Bail applications.
Yes.
See, man,
Additional specialist. Additional specialist, item number 1, BLAPL 6632 of 2024.
no one appears. This matter on next Friday.
Item number 2,
Someone is there in the bail applications. So Friday. Well.
item 3, Mr. Jafrullah is there. Item number 3,
Item number 3, 4, and 7. 3, 4, and 7. 3 accused persons are arising out of one case to one case. But cases are under NBTS Act. But case is that the informant was a police officer while he was investigating a theft case. But while he was investigating a theft case, he got information regarding transportation of contraband, and accordingly he rushed to the he entered inside a bus. The bus was flying from Kolkata to Chandigarh. So, so many passengers are there. They, without reducing that information into writing by the compliance under section 42, he entered, and what he got, he got that he found that in the bus, he found 4 plastic bags kept in the slipper seat besides a person. Who is the second case was one Varun Banerjee, his name. And thereafter,
What about section 37?
37, my lord.
Total 49 kg, 900 gram of ganja. That is, 37 is a bad and commercial quantity of ganja, 37 is a bad name.
That is the difficulty, Mr.
No, but always prima facie they will establish because investigation has been completed, charge sheet submitted. So 2 things, my lord. One,
Once it's submitted, cognizance taken.
charge sheet has been submitted, but yes, charge sheet submitted, cognizance taken, but prima facie, my lord.
Once it's submitted, cognizance taken means prima facie satisfaction.
Consideration of bail, when there is, my lord,
If I record that I am prima facie satisfied that no offense is allowed, then the cognizance order will become bad.
oh, that is the different aspect. When considering bail application, while I am incarcerating, my lord,
Yes.
there are 2 things, my lord. Where,
No, there are not 2 things, there are 3 things.
Yes.
All right, one, you are saying that the prima facie no case is made out.
my lord,
Prima facie no case is made out because there was
prima
recovery
facie-
from you.
my lord, my submission is the first submission. The section 42. Section 42 has not been complied with because
See, Minister, that can be seen at the stage of trial.
my lord, I will satisfy.
Section 37.
Yes, I have seen, my lord. And it's my lord, I will cite your judgment of this honorable court. If it is substantially it is not complied,
So, because from the apparent from the record, if you suppose you have not complied from the partially, if you have complied, then it's a
It will be, see, Mr. Counsel, that will be a very risky proposition. If we start making such observations in bail cases, then if we say that this provision was not complied with, therefore bail, then what will happen for trial? Because that is the finding of the High Court.
I'll cite a judgment. I'll cite the judgment of this honorable court. This is if it is not substantially complied.
There is no question of and
bail has been granted. Bail has been granted by this honorable court.
Bail has been granted, but no law has been laid down. That is such
reported judgment of this honorable court.
If you say so, I may differ.
I'm yes, by citing Honorable Supreme Court judgment, this honorable court has granted.
Judgment is there. That will bind me. I will follow.
That second thing, one will also have to consider. This one is a public. It is not a private vehicle. It is a public vehicle where so many passengers are there. When the things contraband is found from the possession of from the one seat, sleeper seat where the one of the accused was there. His name is Barun Banerjee. He was there. It is the FR. I'm not saying a defense, it is the prosecution case. And other two ladies, all are before lawsuit. They are sitting in other seats, so that those contraband articles were not seized from their bag, from their seat or anything. So how will connect them with the contraband? Because so many persons are there.
You should the submission which you are making, you should have filed an application under section 482 by 439.
Because I'm in custody.
482 you could have filed no offense because and there is no absolutely nothing. So
fancy case, in the fancy what he stated, the person from the seat it is recovered, he disclosed that along with two other persons are also there. They are sitting in seat number one. So whether only that submission when nothing is seized from these two ladies, from the possession of two ladies, can it be constituted case that they are carrying a conscious possession? And in your Tufansing case,
Tufansing was bail.
Pardon?
Was it a bail matter? Was Tufansing a bail matter?
Tufansing case, in considering.
Mr. Counsel, I am again putting the same question whether that was a bail matter before the Supreme Court.
No, that is not only bail matter, but guideline law regarding even the confession of one of the statement of the co-accused is not admissible. So, when the threshold
that Tufansing is on a different
they cannot my submission to lawsuit last occasion that is your lawsuit state has suffered time to go through the what is the further material against us, but how will connect us to with the contraband things. Where ladies where in the other passengers are also there. So it is not a private vehicle that I cannot, it's a court will presume. So presumption will arise.
No question of presuming. The question of the court giving you a clean sheet. That you have not done this.
Because every day other what the co-benches are also granting.
Co-benches may be granting.
Considering the co-accused statement. Co-accused statement they are citing Tufansing case. Co-benches are every day co-benches are granting. I am not pressing for that Barun Banerjee from holds seat, the contaminated seat. But so for the two ladies who are sitting who are traveling in the bus, in another seat, nothing was seized from their possession, conscious possession. So other co-benches are every day. That is my submission before lawsuit. Two things. One is non-compliance of section 42. And if it is, of course, it is a persuasive nature for your lawsuits because the co-bench has granted, has observed, if your lawsuit will permit, I will cite that judgment.
If you permit, I will write a judgment on this section 37.
So 37,
whenever,
particularly in this issue.
On the next day, I'll dictate a judgment on section 37. Taking into account all the decisions of Supreme Court. Let me give me an opportunity, I'll do it. if you give me an opportunity to deal with section 37, I'll do it.
Can I do, my only,
I don't know, unless the courts are given an opportunity to decide matters, the courts don't. So you give that opportunity, I'll decide. What is the scope, what is the embargo, what is the, where this should, court can grant, where the court cannot. Whenever. As requested on behalf of the petitioner, list this matter on next Friday.
Item 3, 4 and 7. 3, 4 and 7. Item number 5.
Based on Friday.
Item 5 and 6. Item number 5.
Yes,
also. Is the bill arising out of Delta case number 980 by 2023 corresponding to J case number 1996.
Which item?
5. Sir, the offense is on the section 395, 400, 457, 458 and 398. And the FR was registered against an unknown person.
In fact, I should rise because I have a meeting.
Sure, please.
I have a meeting, therefore I should rise. The matter on next Friday. Oh,
Already I'm waiting, sir.
You want?
Sir, I'm waiting for 75
Let me
days.
see.
Sir, 75 days.
Let me see. 75 years old.
Yes, no, sir, 75 days.
Huh?
I'm waiting still.
Waiting.
75 days.
Yes, what is the allegation?
There are 395 years, and all accused persons, 2 accused persons have been released by this honorable court, and 4 accused persons has been released by the honorable trial court, respectively. And I have been implicated on the basis of the statement of the co-accused. Nothing, and your lordship, in the entry in the materials involved in the said crime and all the properties are seized by the police officer would not be, that is Nandu, unless Satyaprakash. On the statement of Nandu, I have been implicated. No, not single.
Yes, how do you distinguish his case with the case of Nandu?
Well, Lordship may kindly consider, Lordship may see page 15 of the rejection order. Page 15, my lord. This petition is involved in 17 number of cases of similar nature, my lord.
This is old matter. So all the cases were of the 1718, in the year of 1718, and he got married on the year 2021, and after that he would never indulge in such crimes. He is having
Your lordship, the case of Dokaiti, my lord.
Next Friday also, my view may change. But because of the criminal antecedent, it's very difficult for me to grant you.
Item
Otherwise,
6.
yes.
Item 6.
Next Friday, sir.
No, your lordship.
Mr. Counsel, I'll take up your case next Friday. You, I'm saying,
Item 6.
No, your lordship.
I'll take up your case on Friday next. All right.